Hey everyone, we are live. Sorry I was a minute late there, but we couldn't stop talking with Ryan Dancey, who is very interesting off camera as he is on camera. So I'm going to get right to it because normally we have a little intro and we talk about what's going on, but we don't have time for that.
Hey
Who
everyone,
are
we are live.
who are you,
Sorry, I was
Ryan?
a minute
And
late there.
whoops,
But
who are you, Ryan? And tell us, what is your role in all of this? Aren't you a co-creator of this thing, OGL? It's funny, a week ago, I don't think anyone knew what the OGL is. Now I think everyone on planet Earth is going to know what the OGL is.
Well, I'm currently the chief operating officer at a tabletop game publishing company called Alderac Entertainment, which is more commonly known as AEG. And I have been working with the people at AEG since the early 1990s in one capacity or another, but I have only been working with them as an employee since 2016. 23 years ago, I was the vice president of tabletop role-playing games and the Dungeons and Dragons brand manager at Wizards of the Coast during the time when it was an independent company and through the acquisition of the company by Hasbro. And in that role, I was responsible for leading the group of people that developed and released the third edition of Dungeons and Dragons. And I was the person who championed the idea of doing an open source license for the game content in Dungeons and Dragons, which became the Open Gaming License. And it had a sister license called the D20 System Trademark License, which provided for a trademark and a brand that was used to associate the content that was the game engine of Dungeons and Dragons with the content being created by third parties using the Open Gaming License. So yeah, I was in the room when the magic happened.
And you're considered one of the co-creators. So who was the other co-creator, by the way?
I worked very closely with Wizards of the Coast's in-house counsel, whose name is Brian Lewis. Brian drafted the terms of the licenses. He and I would correspond regularly about those terms as we tried to make them fit for purpose, do what I wanted them to do and do what Brian needed them to do to be legal and valid. And the text of the actual license was written by Brian. So Brian is the author of the licenses.
Okay, so that will answer my first question, which is, who put the word potation into the license?
Yeah,
Because everyone,
the PhD thesis really wanted to
that's
know
the number one question that people want to know. They don't want to, we're not going to talk about the SRD. Potation, really? Potation?
I have never gotten a straight answer out of Brian, but I think that he did it as a little Easter egg for all the people that have suffered through contract law in law school and know that there's a word that no other human on earth knows. And he got it into a license that was going to be seen by millions of people.
reprinted millions upon millions of times.
Yes. He probably is personally responsible for the fact that that word exists in print more than any other human on the planet.
Well, now he's going to be responsible for every D&D and RPG geek to say that word at a session. It's going to be
right.
Potation. And people will all know what it means now. Oh, again, a week ago, never heard of the word. Now it's going to be in every one of my games. There you go. See how much has changed in a week?
I think that one has to do with the ability to transfer a copyright or a work product from one form to another. So potation actually is really important in the sense that it reflects the license's idea that there will be people doing things like taking a printed book and converting it to a PDF. I might be wrong about that because I am not a contract attorney, but I believe that's what potation refers to.
And does Brian still work with Wizards of the Coast, or what's his current status?
Brian is a partner in a law firm called Azora Law based in the Seattle area. We're all in the Seattle area. Brian has a lot of clients in the gaming industry, and I don't know if he currently has work with Wizards or not. Because he was the in-house counsel for Wizards of the Coast at the time, Brian has attorney-client privilege restrictions on what he can and cannot say about his time at Wizards and the work that he did for them. And like a lot of lawyers, Brian is also bound by a lot of confidentiality agreements. So like Brian probably doesn't talk about his client list very much. And I've never asked him. I don't actually know if he's done work for Wizards in the recent past. most of the people that worked at Wizards in that era left the company on very good terms. So there wouldn't be any particular reason why they wouldn't retain his services if they needed it for some particular reason. But I don't know if that's currently true or if it has been true in the recent past.
I happen to know that he at least worked for Paizo back when I was at Paizo, which is about a year ago. So at the bare minimum, he was very recently working for Paizo as one of his clients.
Yeah.
And once again,
he and his firm represent our company, All Direct Entertainment Group. So he's technically my lawyer, although not my personal lawyer, but.
And once again, do like and subscribe. If you subscribe,
looks
you
like
can.
An 11 million sub channel just mentioned us.
Oh, exciting!
So maybe more people are coming.
Mash that like button.
Yes, like the like button, and well, even subscribe, because then you can. Because I go live at a moment's notice, and you're not going to know unless you subscribe. Because
so something that's pretty decently newsy is that speaking of Brian Lewis, there's an email or a message going around that was seemed to be from Brian Lewis that said that Brian Lewis is working on like a new more ironcladly open license and wants to have designers and publishers vet it. And Ryan, you were saying that definitely is from Brian, and Brian is pushing this, right?
Yes, I received an email from him this morning that has that content in it, and I correspond with Brian regularly, and I got it from the email address that I correspond with him at. So I have absolutely no reason to doubt the authenticity of that message.
I had no reason to doubt it, but I got it from like a person who got it from him, so I didn't get to see any data on it or anything like that. And I'm people may not think that because of the fact that, you know, like we published the leak first, but I definitely vet my sources before, I'm sure. But Ryan, if you got it from Brian, then I'm pretty 100% confident this is something real that Brian Lewis, the author of the OGL 1.0, seems to be doing.
Yeah, I received it too, but before I started to talk about it, I wanted to get secondary confirmation, because everything I've been doing so far, I've been always getting secondary confirmation, because I don't want to spread any rumors that aren't at least confirmed. So with that being said, let's get into the meat and potatoes, because a lot of people are saying, oh, we don't know what the original intent of the OGL was.
I do.
Good. Thank you. That's the whole reason you're here. Please tell us. Go back in time to 1999 when no one ever heard of anything called open source, and you had to go through extreme lengths and pains to tell people there's this thing called Linux and there's this thing called open source. I want to go through and explain this weird concept to you.
Yeah. So let's lay some background, because there is some interesting history.
Okay.
Wizards of the Coast was started by a guy named Peter Atkinson and his friends to publish content that they were developing in and around their homebrew role-playing game sessions. Wizards of the Coast is actually a faction in his homebrew campaign, which is called Chaldea. And they created a thing called a cap system. And the idea was that they would publish products that were designed to be universally usable by people playing all different kinds of role-playing games for the kinds of game systems that those games rarely implemented themselves. Their flagship line was called the Primal Order. And it was a cap system designed to provide rules for how gods and godlike powers could be added to your homebrew role-playing game campaign. That book came out in 1991-ish, very early 90s, maybe late 80s, but I think early 90s. And there was a time when Peter wanted to have a thing called the Envoy system, which was a way for publishers to tap into the products that he wanted to make in this capstone concept, so that they could make products that were compatible with his stuff, and he could make products that were compatible with their stuff. They published the Primal Order and got sued. And the lawsuit came from Palladium. And the objection that Palladium made is that the Primal Order capstone book that Wizards of the Coast published included rules on how to use the Primal Order material with the Palladium role-playing game system and with riffs. And Wizards of the Coast was a very small company. It was like Peter and his wife in their basement, and they didn't feel like they had the ability to litigate that matter to determine if the claims were merited or not. And at the same time that was happening, they published Magic the Gathering. And so there was a thought inside the company that they should protect Magic the Gathering against the potential of a lawsuit from Palladium. And so they settled with Palladium. And the settlement was, I believe, I remember reading at the time, but I don't have all the details, a fairly small amount of money and an agreement to put a sticker on every copy of the Primal Order that was still in the warehouse that said, this product uses unauthorized material from the Palladium role-playing game system and Rifts and is used without permission. And that was the end of it. And then the company went on to do Magic the Gathering. So there was this kernel of the idea that role-playing game systems should be usable by other companies without an onerous licensing regime embedded in almost the birth of Wizards of the Coast. And then it was forgotten. Like, they moved on. They got other things to work on. Magic the Gathering was kind of a big deal. You mentioned, open source as a concept was kind of hard to understand in 1999. And that's true. But if you were in the computer field, in the internet field, in the 90s, you were very aware of open source and the concepts of open source software. Yep. The internet, in large measure, is powered by open source. And critical pieces of the technology that made the internet possible arose from open source projects with start dates back into the 1970s. Turns out, I'm a technology guy who was involved in the internet in the 1990s. And so I was very aware of the concept of open source. There were some folks inside Wizards of the Coast who also had suggested that we should look at using some open source concepts with regards to role-playing games before I started to work on that. And I wouldn't even be shocked if somebody could produce an email from me saying, that'll never work, we shouldn't bother. So why did we have a sea change? Well, let's talk about the role-playing game business in the late 1980s and the early 1990s. It was very, very good to be a role-playing game publisher in the 80s and the early 90s. There were a lot of very cool products that came out in that era. The White Wolf games, Vampire the Masquerade and all of its parallel worlds, started being released in 1991. There was a huge influx of new players into the hobby at that time, mostly drawn by those games. There were a bunch of people that had been gestating ideas for games for a long time. A lot of people in the Midwest that were associated either loosely or closely with TSR, who went out on their own and did their own thing. So that was kind of a golden era for RPGs. But in the late 90s, things were very, very different. And this was not a problem that was exclusively related to TSR. So there's a million things we could talk about why TSR failed as a business. But the failure of the role-playing game category is not a TSR phenomenon. It was a category phenomenon. Most of the companies that were publishing role-playing games in the late 1990s were very unhealthy. Some of them had already started to fail by that point. And although bankruptcy is fairly rare in this industry, there are lots of companies that just cease publication, liquidate their inventory, and kind of go into a fugue state of non-operation while their owners try to figure out what to do next. And a lot of that was happening in the late 1990s. Things were very, very bad. So when Wizards of the Coast bought TSR, which was a deal that I helped broker in my role as a principal at a company called Five Rings Publishing Group, Wizards bought a tremendously valuable intellectual property and a tremendously dysfunctional business. And in 1998, late in 1998, Peter Atkinson, who is the CEO of Wizards, he asked me to take over the business of managing the D&D role-playing game lines and all the other role-playing game lines that they had acquired from TSR, Alternity, the Saga system. I'm sure there were others. And so we had a meeting where the finance team at Wizards, the strategic planning team at Wizards, the R&D development team for RPGs at Wizards, the marketing and sales teams at Wizards, and me sat in a room with Peter and Vince Calori, who is the executive vice president at the company. And I call that meeting the dirty diaper meeting. That is the meeting where it was kind of laid bare how absolutely bad the business was, how little revenue it was generating and how high its costs were. And I walked out of that meeting and I was given very clear instructions by Vince to figure out what went wrong, fix it, and make sure that that business made money. So that was a blessedly clear direction from executive management, which doesn't always happen in large companies. So my team and I started to talk about and brainstorm what had gone wrong and how to fix it and how to make money. And I had an amazing team. I tell people all the time, my counterpart on the R&D side is Bill Slavisek, who is the head of the tabletop RPG business. He came to Wizards of the Coast from TSR, and Bill and I had a partnership. We compartmentalized our work. So I would focus on business and marketing and strategy, and Bill would focus on design and development and making great products. And throughout the time we were together at Wizards, that partnership worked extremely well. I didn't have to go fight battles over design, and Bill didn't have to come fight battles over strategy. If either of us wanted something from the other, we just dealt with it at that level between the two of us, and we were able to resolve those issues really easily. So my team was Lisa Stevens, who was the first paid employee at Wizards of the Coast, was deeply involved with the RPGA, which was Wizards and TSR's fan-supported organization for role-playing games. She had been an employee at White Wolf at the birth of White Wolf. So she had seen and done a lot in the industry, knew role-playing games intimately. I also worked with Jim Butler, who was a TSR designer and is currently the CEO of Paizo. I worked with a guy named David Wise, who was really involved at TSR on the publishing side. If you read Ben Riggs's book, you'll read a lot about Dave. Dave is an amazing guy, and he brought a wealth of knowledge about the history of TSR and how it had operated at an executive level to the table. Keith Strom, who he was a TSR employee, but he was barely a TSR employee. Like, I think he started work there a year before the merger happened. And Keith and I, Keith essentially became my number two. He was responsible for a lot of the management of the business, day-to-day business of Dungeons and Dragons. We called him the category manager or the business manager for D&D. We also had people like Cindy Rice on my team, who went on to work in the licensing division at Hasbro and now is a successful producer in Hollywood. Anthony Valterra, who is spending some time as a college professor, I believe. He's also done a lot of really great publishing. I don't want to forget anybody, and I'm sure I am, but there was just an amazing team of people in that room. So one of the things we identified as a problem was that there were all kinds of game systems that were active in the market that weren't very successful. And every one of those games was a little bubble, a little social network of people that played that game. And because they were playing a game that was small and unprofitable, and the companies that were supporting those games were not able to make those businesses get bigger, the sizes of those bubbles was shrinking and getting smaller and smaller and smaller. And because they were not well connected to other bubbles, the overall market as a whole was shrinking and getting smaller and smaller. And role-playing games are heir to a very unusual economic phenomenon called the network externality, which means that the value of the thing you sell, the product, is actually external to the thing that you sell. It's in the network of people that use that thing. So the canonical example is telephones. If I am the only person in the world who owns a telephone, my telephone is worthless. But every additional person who gets a telephone makes my telephone more valuable. Not because my phone got more valuable, but because the number of people I can call with my phone has increased, and therefore the network is valuable. And role-playing games are just like that. The number of people that know how to play a game that I want to play is the value that I have for that game. And the more people I can find to play that game, the more likely I am to play it. So bigger networks of games are more valuable than smaller networks of games. And we were trapped as an industry in a world where all of the networks were getting smaller and smaller and smaller, and they weren't connected. And so we turned to open source. And we said, okay, obviously there's problems with the idea of having all these companies attempting to do licenses with each other. It would be onerous to the extreme for there to be a licensing regime that required approvals and reviews and money changing hands and all the stuff that comes along with traditional licensing. But open source doesn't use any of those things. And there are open source projects which are enormous. You mentioned Linux before. Like, that is an enormously large and complicated project with thousands and thousands of contributors, some of which are huge companies and some of which are just individual people. So we had a model. We could look at that and say, okay, this is possible to organize really large, really complex things with licenses that are extremely simple, very transparent, and don't have a lot of onerous requirements on the part of the licensors or the licensees. Can we make one for gaming? And we did. We worked really hard with the Wizards legal team, and then we created a portal via a mailing list called OGF-L. I'll talk about the OGF part in a second. That allowed anybody who wanted to interact with me and via me with our legal team in developing these licenses and making them make sense and accomplish our objectives and listen to and accept feedback from the community about things they liked and didn't like. It made them work. It made them better. It gave them buy-in so that people felt like they were vested in those licenses and how they came to be and what was inside them. So a lot of open source projects have an entity that is connected to them in some way, which is kind of the residual place where all of the work and effort eventually is collected. So the Free Software Foundation is an organization started at MIT by a guy named Richard Stallman, who is considered by some to be the father of the open source concept. And there are similar entities like that for a lot of other projects. So we created one. I made this thing called the Open Gaming Foundation, and I made a website, and it is very basic. It's opengamingfoundation.org. It's almost not there. It's barely there. It just has some very simple links to some licenses. And it created basically just a point in time reference where we could put a flag in the ground and say, these are the principles of what open gaming means. This is what we are trying to do. And this flag in the ground will be here so that if people in the future want to look back and say, why did you do what you did? This is it. This is the landmark. You can come here and see it. This is why we did what we did. And that's what it's for. And it's still there. There's a very simple declaration about open gaming being about the ability for people to use and exchange and modify and distribute game rules that are free from onerous, restrictions, and that games should be free, that philosophically they shouldn't be bound up with intellectual property law, and you should be able to make versions of games and make cool new things with games, and that's just good for humanity, and therefore it should be. And the Open Gaming License is a vehicle to make that true in a world full of copyright and trademark and patent law. Yeah, so that's the genesis. That's how we got to the strategy of the idea for having an open gaming license. We wanted to make it a zero friction environment for anybody who wanted to make content for a game that we thought was going to be the largest social network of a role-playing game, which was Dungeons and Dragons, in a way that wasn't going to cause problems for anybody who wanted to use it in terms of overhead of legal review and process and finances and all that stuff that comes along with lots of licenses.
So when you said that it wouldn't cause problems, would you say that you intended for it not to later be revoked or
Yes.
revocable?
Yes. Yes. So the language of the open gaming license is crafted with the context that we could look at a lot of open source software licenses to see what they did and how they did it. And obviously, one of the things that is very important to any open project movement is that you don't want the content that people contribute to that project to lose the qualities that have been given to it via the licensing regime. So the license itself is the foundational document that preserves and protects the rights for people to get the value out of the open content that is created by the project. If the license itself could be revoked or terminated, then there would be a risk to all parties involved that at some point the work that they had done would become valueless, and therefore they wouldn't contribute in the first place. So it's axiomatic that the license has to be unrevocable, or no one will use it.
So you answered obviously the elephant in the room question that everyone wanted to know is whether or not you can really revoke it, even though it doesn't say directly it's irrevocable. But using analogies and language used at the time and the core concept of open source, that if it was revocable, why would anyone use this?
Yeah, that's right. Yeah.
That makes
So
sense.
some people have asked, why does it talk about authorization? And that's a good question. And the reason it talks about authorization is that because we engaged in this public process for drafting the license, there were many versions of that license that circulated in an unauthorized format because they were circulated so we could get comment and feedback. No open game content was ever licensed with those drafts of the license. They were never used, but they do exist. And somebody could perhaps produce one and point at it and say, well, this is a version of the OGL. And the OGL itself says you can use any previous authorized version. So I'm using this one. So to make it very clear that there was a point in time when the license came into effect and became authorized, that language exists in the license. And that language, that the authorization of the license of version 1.0A happened at a certain point in time. And that date, that moment is when the license exists as a legal document. But up to that point, it's just a theory. But at that moment, when we published that thing and said this is authorized, that is when the open gaming license begins. And
So
there is
to
no
be clear
language in
to
that license to deauthorize. If that was a power that we wanted to have vested in Hasbro or Wizards of the Coast or anybody who was an antecedent who owned the copyright to that license, we would have added that language to the license. It's not there on purpose.
Perfect. Perfect. So I'm wondering when or I guess to rephrase that, that means that the point of the even saying authorized in the text was to stop rules lawyers from trying to use some like proto version of it that did not have all the final language. There was no other, there was no reason, there was no possibility for deauthorization.
Absolutely. Also, it assured people that it was real, that it wasn't a hoax, like that this is an actual thing that was really being done with intent. It wasn't just some guy in the marketing department publishing something on a website. Like this was a formal action of Wizards of the Coast to do this, like that it was a real actionable legal event.
And something I want to mention that some people don't realize, when this was released, Wizards was owned by Hasbro at this point, correct?
Yeah, that's right.
And that's something very important to keep in mind, is that this was done under Hasbro's watch. This wasn't something done before Hasbro purchased Wizards of the Coast. So they're very much aware and were part of the creation of the original OGL.
Yep.
And something else, I was going to say, and something else I want to follow up with is, so tell us a little bit about, was it successful? Did the OGL do what you intended it to do? Like tell us those early days when people were starting to want to start using the OGL. I mean, nowadays it's commonplace, but back in the very early days, like, how did you get the word out and how did people react to it?
Yeah, it was a very hard lift. Lots of people were concerned that it was a trap, that we were going to get all these companies to put their content into an open game environment, or that we were going to get them to divert work from their own role-playing game system and their small network into our big network. And then we were somehow, after that happened, we were going to yank the rug out from everybody and steal their content. People are suspicious and creative people are very suspicious. And so it was a very lengthy process of engagement and communication with industry pros to address their fears. And we were very lucky that there were a few lawyers who were not connected with Wizards in any way, who participated in those processes and were available to tell other people that what we were saying was true, that we weren't lying about what we were saying, and that things like open source content licenses are real and they really can work and really exist. I attribute the immediate success of the project to the fact that some companies made a what they perceived as a very risky gamble to have products ready to go on the day that the license was authorized, which was the first day of Gen Con in the year 2000. And they did that under what we call the gentleman's agreement, which was, I promised them that the terms of the license that they were working on and the terms of the D20 trademark license they were working on were actually going to be authorized and come into effect, and that they would not get caught with a bunch of inventory that they couldn't sell. And Atlas Games, Green Ronin, and White Wolf took that risk. Atlas and Green Ronin actually had third-party D20 open gaming license product published and on sale the first day of Gen Con in 2000. And then White Wolf and their partners at Necromancer created in warp speed a monster manual called the Creature Collection, and they had that on sale very shortly thereafter. And I think that activity by companies that had reputations in the industry that were meaningful was the thing that kind of broke open the floodgates. And when people saw that that had happened, and that we hadn't screwed those companies, and that there hadn't been a secret plan all along to jack them, and that they were selling a ton of product, all of a sudden everybody was all on board, and it was just like a light switch went on and we were off to the races. And after that point, I never had to explain it again. Like, I never had anybody after that point say, isn't this all just a big trap? Like, it was just over. The risk that it was a trap was gone, and people were instantly comfortable in using the license.
By the way,
so there's a few super chats that.
Well, I want to actually say that, Mark, is that if you do super chats, we will answer them. I actually want to get through this part first, and then we'll answer the super chats.
I have
in
a
the
follow-up
second
for
part.
one thing that Ryan just said. I'm very interested in. You said that there were other lawyers that did not represent Wizards, but that did go on the record to companies saying this is legit, it's not a trap, they're not gonna be able to pull it back. So you mentioned before that since Brian Lewis did represent Wizards and had attorney-client privilege, that he's very limited in what he could say. What about those other lawyers from back then who did not represent Wizards?
I mean, the most visible one of that group is Clark. Oh my God, my brain just blanked. Clark Peterson and Clark.
Necromancer Games.
For Necromancer. Yeah. He's an attorney. He became a judge. And Clark was involved from the first day almost, commenting and providing input and feedback and stuff. I'm not exactly sure when we figured out he was a lawyer, but I don't think it was a secret to anybody that he was a lawyer. He wasn't trying to hide that fact. And because he was so deeply involved from such an early time, I know that there are people that listened to what Clark said and respected the fact that somebody from outside the Wizards envelope was validating our claims. And I'm sure he wasn't the only one. I mean, this is 23 years ago, so I don't exactly remember. And I don't know the professional credentials of all of my friends, but I'm sure there were at least 2 or 3 more attorneys that were of record who were willing to step up and say, no, this license is real. Yeah.
And one of the key aspects of the license, which I want to get into, and I've mentioned this many times in the streams, is that if Wizards wants to create a new OGL 1.1, they can. That's fine.
Absolutely.
But they can't invalidate or disallow people to use the 1.0A now or even in the future.
Right. So we anticipated the idea that it might be possible in the future, or it might be necessary in the future, for a new version of the open gaming license to be released. And the license itself has rules for how that can be done. And it explicitly says that you can use any authorized version of the license. So in other words, we were basically saying, if you are using 1.0A for your work, you can continue to use 1.0A forever. But we see that it might be that in the future, there's a need for a 2.0. And if a 2.0 gets released, you could use that license too. And the only reason that you would ever use that license is if it offered you benefits that the 1.0A license does not. And who knows what those reasons could be? We don't know. Like, we're sitting here in the year 2000 and we can't foresee the next 1,000 years of legal evolution. Maybe we need to have a new thing at some point in the future. everything has to be a gift. You have to say to the community, we're going to give you 2.0, and in exchange, you're going to get all of this other stuff, this new stuff, the stuff you don't currently have, that will be a reason for you to start using 2.0. What you can't do is say, here's a 2.0, and you have to use it whether you like it or not, even if it takes away rights that you currently have or makes your life harder. Like that gets back to the fundamental question of why would anybody ever use the license if you could do that? If you could do that, no one would use the license.
And something else I want to mention is that some people are saying that the OGL was only designed for printed books and that's it. And that you couldn't use it for things like, oh, I don't know, video games or PDFs or VTTs. But in a FAQ that Wizards of the Coast published in 2004, you clearly state that not only can it be used for video games, but here's another FAQ that explains how you can use it for video games.
Yeah. That was after my time at the company, so I'm not responsible for that. But if you had asked me, and I was asked many times, could it be used for video games? My answer would be yes, but it will be difficult. Correct. So there's nothing in the OGL itself which restricts you from making a video game. Nothing. The challenge is that the OGL requires that you clearly identify which parts of the work that you are publishing is open game content. You are optionally allowed to declare what parts of your work is product identity, which is stuff that you can't use without separate permission. But the core of the issue is you have to be able to identify which part of the work is open game content. If I published the full source code for a computer program, it would be easy for me to say what parts are open game content. Just like if I publish a book, I can say chapter 2 is open game content. I could, in a piece of published human readable source code, I could clearly identify what parts of it I believed were open game content. If I publish a binary, that becomes much harder because, in my opinion, it is not possible to clearly identify what parts of a binary are open game content and what parts are not, because it's not human readable. There's probably a million ways to work around that problem, and I'm sure that people have worked around that problem down through the years and tried to figure out how to do it. I've never been involved in any of those efforts. So I've actually never published anything using the open gaming license. I've never published a single word.
How ironic.
Yes, but I'm not in a position where I could say that something is or is not compliant with the open gaming license with regard to software, because I would have to do a really deep dive into it to see what they did and how they attempted to do it. I was having a conversation just last week with somebody about this topic, and I kind of moved off of my position, which was pretty hard for a long time, which was it would be basically impossible. And now I am prepared to suggest that maybe I could see some ways where it could be done in a way that would make sense. But
the whole concept...
Never was there a ring fence around the open gaming license that said you can't use this for a digital product or a video game, right? Never. We were in the business of licensing Dungeons and Dragons for computer games. When we were doing 3rd edition, the first Baldur's Gate game was released. So like it isn't like it was a foreign concept to Wizards that you could make a digital version of Dungeons and Dragons. If we had wanted to stop people from doing that, we would have written that into the open gaming license. My memory's hazy, but I think there are restrictions against doing that in the D20 system trademark license. The D20 system trademark license is an optional additional license that you can accept if you want to put the D20 system trademark logo on your product. So it does not alter the open gaming license in any way. You don't have to use it. But if you choose to use it, you accept a whole bunch of different restrictions on what you can and cannot publish. And that's where we would have put things like a restriction against having a video game. It would have been in the trademark license, not in the copyright license.
And it's important to note that back in the year 2000, things like PDFs and video games and the internet and email, that all still existed back then.
Yeah, it all existed.
It all existed. Yep. So it's not like you suddenly weren't thinking of this. Yeah. These were things you were thinking of when you created the OGL and that you were quite aware of, I believe.
Yes, absolutely. I mean, let's talk about something that's really important, and that is, what is the OGL actually licensing you? So on the face of it, what it's licensing you is the right to use open game content, which is content that is defined by its contributors. The copyright law says that you can't copyright a system or a process or an algorithm. And it has been stated by the US Copyright Office that game rules cannot be copyright. But that, while it sounds like a black and white statement, is not as black and white as it may first appear. And the reason is that there is a point where a game system is transformed from a system or a process or an algorithm into a work of art, into a work of fiction. And where is that point? Where does that transition occur? When does the ability of a copyright holder to restrict you from making a derivative work begin? And the answer to that question is that nobody knows. It would have to be decided in a court of law on a case-by-case basis by a judge and a jury, looking at the particular facts in a particular dispute between parties and making a judgment that would only affect those parties unless it got to higher and higher levels of the court system. So it's a giant legal gray area, and legal gray areas are massively risky because you can't calculate what your exposure is. You don't know what you're risking if you operate in a legal gray area. So the purpose of the open gaming license is to get rid of the gray area. It just goes away. We don't have to have an argument about whether or not a game rule can be copyright. We don't have to have an argument about when my description of Darth Vader becomes copyrightable. Like, it doesn't matter. The open gaming license sets out a clear system for saying you can use this content under the terms of this license without any fear of being sued under a copyright claim. It just eliminates the copyright claim, right? So that's what it does. That's its fundamental thing. Okay. Could you just make another version of Dungeons and Dragons? Maybe. I can't make Drizzt or Elminster, but I could probably make something that was a system or a process or a method or an algorithm to explain how I roll a random number generator, compare it to another value, and determine if there's an output. Like, that can't be copyright. Are the 6 ability scores copyrightable? Hard to say. Variations of ability scores have been used in lots and lots and lots of games that are not licensed by anybody at Wizards of the Coast. So could I make a clone, an absolute complete clone of Dungeons and Dragons and publish it? Nobody knows the answer to that question. So could I make a version of a Dungeons and Dragons computer game? It uses the rules of Dungeons and Dragons. Well, there's 2 parts to that question. Could I use the rules of Dungeons and Dragons? That's a gray area. And the answer to that question could be yes. Could I call that game Dungeons and Dragons? The answer to that question is no. That's a trademark question. And trademark law is much more defined about when it starts and when it stops and how it is enforced. And Wizards of the Coast absolutely owns the trademark to Dungeons and Dragons. You cannot make a product and say, this is Dungeons and Dragons. So you couldn't publish your own Dungeons and Dragons computer game. However, it is well established in trademark law that you can claim compatibility with another person's trademark if the compatibility is accurate. I can't claim to be compatible with your gaming system, with Nintendo or your Xbox, if I'm not actually compatible. That's not allowed. But if I actually do make something that's compatible, the trademark holder can't stop me from claiming compatibility. The open gaming license says that you cannot use product identity if you do not have a separate agreement from the holder of that product identity to use it. And Wizards of the Coast has declared that Dungeons and Dragons and a bunch of other related trademarks are product identity. So if you publish a game using the open gaming license, you are not allowed to claim that that game is compatible with Dungeons and Dragons. Trademark law says you can, but you have agreed voluntarily to the open gaming license, which says you cannot. If the open gaming license went away, and I had a game that was functionally identical to Dungeons and Dragons, and that game survived a challenge in court saying that it was an unauthorized derivative work, and the court said it was not, and I was allowed to publish that game, and I was not using the open gaming license, I could publish that game and claim that it was compatible with Dungeons and Dragons. So the risk that Wizards of the Coast is taking with the idea that they can revise the open gaming license to create a more onerous version of that license is that somebody will make a game which is identical to Dungeons and Dragons, which does not use the open gaming license, and will claim that it is compatible with Dungeons and Dragons. And Wizards will lose everything. They are playing with atomic fire over the control of their brand. And right now, they are safe. They are completely protected. The open gaming license protects them. If they lose the open gaming license 1.0A, they are in the wild again on whether or not people can make compatible products and claim they are, compatible with Dungeons and Dragons. It's an unfathomable risk to me to be taking at this juncture. It's literally insane. I don't understand it.
So we have been getting a whole bunch of questions, and this is beyond fascinating. And I can listen to this for hours, but I do want to get to a couple of super chats, and I'm just going to go through them real quick. Lord God said, are you aware of any similar licenses being revoked, specifically those with similar language to the OGL 1.0A? Thanks. Basically, he's asking.
Aware of none.
Okay. So basically,
there was one before that too that was almost the same question, which was, did you know if the word irrevocable was being used in the field at that time for similar contracts, or was it something that may have been added on later due to Laura's arguments on other open licenses?
I have to punt on that question and say that I'm not a trademark attorney or I'm not a licensing attorney. That wasn't my part of the responsibility, so I don't know if it was being used or not.
Okay.
Personally, I do not believe that term needs to be in that license to make it unrevocable. I hate the idea that just because it doesn't say it isn't revocable, it's revocable. That's crazy to me, but I'm not an attorney.
Joey B sent $5 before that one. He said, for Ryan, do you have the authority to sign contracts when you made the OGL FAQ? If so, the answers are likely binding on the company under contract law. Not exactly sure what he's asking. That's not how the world
works, unfortunately.
Okay.
I mean, anything that was issued by Wizards of the Coast and published on the Wizards of the Coast website or in a Wizards of the Coast publication, it is the court is going to assume that material represents the opinion of the company, not the opinion of the person who did it. It's never been repudiated. Nobody at Wizards of the Coast in 23 years has ever published something and said, Ryan Dancey was a crazy man. We don't know what he was saying. That stuff is nonsense. None of that is binding. They've never said that.
Edgel Monk says, Ryan, it's Fisher. You may remember me and Mike from back in Seattle in the day. Love you, brother. So that's for you, not right for any of us. Joey B sent a super chat and says, thank you, Ryan, for coming in channel, and thank you, Stephen, for setting this up. Shout out to Mark too. Hey, look, he talked about you, Mark.
He did.
Tyler Hubler wrote, for when you get to super chats, what's the difference in using the OGL versus Creative Commons approach? I see a lot of publishers using Creative Commons.
Yeah. Okay. Creative Commons. So for those of you who don't know, Creative Commons is a collection of licenses that are designed to provide a foundation for various open content projects. And they existed at the time we did the open gaming license. At least some of them did. So why didn't we use Creative Commons? And my answer is that there's multiple licenses. Creative Commons, the idea behind Creative Commons is that they could create a whole fractal space of licenses that added and subtracted ideas from the open source community, adding and subtracting control and responsibility and oversight between project creators and people who wanted to use the contents of that project. There are versions of the Creative Commons license that are as open as anything that Richard Stallman would be pleased to have his name on at the Free Software Foundation. There are also versions of the Creative Commons licenses which are as restrictive as any deal you'll get from Lucasfilm. The problem is that if you tell somebody this is licensed with Creative Commons, some people will assume it is the most liberal version of the Creative Commons license. Other people will assume it is the most restrictive version of the Creative Commons license. And no amount of telling people, oh, no, this is CC-YA-U-X license. It will fail. And what you will end up with is the same gray area problem that we have now in copyright law, multiplied by the fact that you're going to have different versions of licenses applied to different content that all are mutually incompatible. That's just human nature. That is what is going to happen. With the open gaming license, we already had people trying to twist its language and say that it said things it didn't say, even though it's a very simple and easy to understand license. I knew that if we tried to use Creative Commons, that problem would just multiply. So we never gave serious consideration to using them, not because they are not good licenses, not because they are not well drafted, not because they don't work. They're being like Wikimedia. The Wikipedia runs on Creative Commons licenses. Like, they can be used. They were just a bad tool for our purpose.
So one thing we were talking about before we went live that I think should be touched upon is that because a lot of people have been saying this is going to be decided in the courts. This is going to be decided in the courts, and they're worried that this is going to take years to go on.
Yeah.
But what is your opinion on that? Because you had a very different opinion.
Yeah. So 2 weeks ago, that was my opinion. And then I had a conversation with a few people I respect, and they said, this is not a complicated case at all. This case is going to be decided solely on the question, does Wizards of the Coast have the right to deauthorize 1.0A? That's it. That's the only question.
Mm-hmm.
And that is not going to be a difficult question for a court to make a ruling on. It's possible that the judge could rule from the bench on the first day of the trial that the license does not provide Hasbro with that capability, and it would be over. I felt like this was more like Oracle versus Google and the fight over the right to use the Java API, but that's a copyright lawsuit. That lawsuit is enmeshed in the question of whether or not you can make a derivative work of something in a way that wasn't fully understood at the time the copyright law was written. The question of whether or not Wizards of the Coast can deauthorize 1.0A is a contract question. And I don't believe that question is hard to answer. So I have changed my opinion. And now I think that if it actually got in front of a judge, you could get a ruling very, very quickly. And if you get a ruling very, very quickly, it will be the worst possible ruling that Wizards of the Coast could get. It will destroy them. It'll destroy their legal position with regards to protecting, Dungeons and Dragons. So I suspect there are people out there that are spoiling for that fight, and they would love to get in front of that judge and see what answer they get. And it only takes one. Like, Wizards could litigate 100 cases in venues all across the country. And if a single judge rules that they do not have the power to deauthorize that license, that ruling is going to be the ruling that gets punted all the way up as far as people choose to appeal it.
And that's what I've been saying all along. A lot of people are making a big stink about the fact that they're trying to steal everyone's work. Everyone's talking about royalty payments. And if they want to do that in 1.1, go right ahead. They can do anything they want in 1.1. That's not the issue. It all comes down to what you said. It just comes to, can they revoke 1.0A and force everyone to 1.1?
Yeah,
that's the key. That's it. That's all we care about at this point.
Yeah, that's right.
As you said, it's like, this doesn't even have to go to trial. It's a 900-word document that's been used by hundreds of thousands of people for 23 years. There's a huge amount of precedent. It probably will get a bench ruling. And if it does, that's it. It's game over.
Yeah. I mean, the ruling that could happen is that a court could just say, you don't have that power to deauthorize it, which, I mean, in the great scheme of things, that just is status quo and there's no change. The really dangerous ruling is if a judge goes through the OGL to the fundamental underlying question of what is copyrightable in a role-playing game, and a court somewhere says, none of this is copyrightable. None of this. Like, okay, you can have a copyright to Drists, and you can have a copyright on the actual specific words used in the rulebook in the order in which they were published, but you can't copyright the game mechanic. Well, then Wizards loses everything.
So they are, as you said, playing with atomic fire. Like, they could either win big or literally lose everything.
Yep,
if they're not careful.
And what do they win? Okay, let's talk about that. So let's say it works and they succeed. They deauthorize 1.0A. Nobody uses 1.1 because it's a poison pill.
Mm-hmm.
There might be a whole new generation of people who come along who use it because that's the license that's available and they want to scratch the itch of being a publisher for role-playing game content. But all the existing people are going to just refuse to publish, right? They're just not going to use it. What does Wizards of the Coast win from this? Like, from my perspective, they win nothing. Like, the value, the total combined value of every single company publishing in the open gaming space right now is a drop in the bucket compared to the revenue that Wizards of the Coast is making from Dungeons and Dragons. And nothing that any of those people is doing is proving to be a competitive threat to Wizards in any way. And the value of Dungeons and Dragons today is orders of magnitude more than it was in 2000. So how do you argue that it's damaging your business for this thing to exist? Your business has done nothing but get more valuable over the past 23 years. There is no business case here that I would sign on to that says that the risk that you're taking is worth the upside. And I can't even tell you what the upside is going to be. It's not going to be that all these content creators switch and start using 1.1. They're not gonna. So they're either going to stop publishing, they're going to go to some alternative, or they're going to fight you in court over the right to keep using what they're doing right now. But they're not going to switch to what you want to do. You're not going to get that. It's not going to happen.
I have a few more super chats. Let's see. When you get to, here we go. King Graham Johnson says, would it be possible for several smaller companies to pull their resources together and hire a lawyer to battle Hasbro as they attempt to revoke 1.0A? Yes.
Sure.
Of course they can. Anyone can do anything. But I think a lot of big people like Paizo and even Cobalt and some of the other big people, they're ready to fight. Minecraft Dragon sent a super chat. What would Ryan say to those people who are most impacted by this new OGL? Should we ignore the new OGL 1.1 and continue to use the old one?
You know, I've actually had that exact conversation with some folks in the last 72 hours. And I have told them that I don't envy them. They're in very difficult positions. If you have a staff of people that are depending on you for a paycheck and you are paying the income that supports them and their families, you are making decisions that are affecting real people's lives. And I can't give advice to anybody and say you should or shouldn't use a license for a game content because you ethically feel like you want to fight the battle over whether gaming content should be free or not. That's an individual decision that each individual person is going to have to make in the context of their own lives and their own businesses. There is no one size fits all answer.
Yeah, as my lawyer likes to say, it's whatever you're comfortable with. whatever allows you to sleep at night. So that's something I think everyone has to decide for themselves. Joey said, ask the judge to delay enforcement of 1.1 until the trial is ended, then Hasbro can't make money off of it until the trial is over.
I'm sure that will be one of the things that some of the litigants will suggest. I'm sure. Like, why not? You can ask for anything in a courtroom.
That's, I mean, and I've even said that. It's like they can say it's revocable, but that doesn't make it true. I mean, they can say anything they want in there. One thing I wanted to ask is that why, and everyone keeps saying this, and I know you answered it again, but I think we should cover it. It's like, why was the term irrevocable not put in? It's like the one term that everyone's latching on to.
You know, here's my opinion. I believe that the word perpetual is sufficient to indicate that the license will go on forever. The idea that you can say that something has to have a term that says if it is either revocable or unrevocable is a construct in a courtroom that is not related to the way humans do business. It infuriates me that I can say, well, the license doesn't say that I can't do something and therefore I can do it, when the clear intent of the license is that you can't do the thing that you say that you want to do. So there may be case law that says that if a license does not say is unrevocable, it is revocable. That is nonsense to me. And I don't want to live in a world where that is true. I might be living in that world, but I don't want to live in that world. So let's just hope that that theory doesn't apply to a license that says that it is perpetual and has rules for how it can be updated. Like, there's a million guardrails in that license. It shouldn't, the absence of one word shouldn't decide whether or not the whole construct can be torn down or not.
Yeah, I mean, I've spoken to a huge number of contract and IP lawyers, and they all say it isn't possible to write something for every possible contingency. And, you know, you did a pretty amazing job for a 900-word license that's held up almost bulletproof for 23 years. And the not having one word in there, I can't see that taking the whole thing down. It seems impossible, in my opinion.
Yeah.
Patriotic Gestalt gave us a $10 super chat. Thanks. That was it. Chris
I don't think
Moore.
there was anything after that.
There wasn't. Chris Moore sent $10. It says, if 1.1 is created for 6E and 1.0A stays legitimate for 5E and earlier, what's the likelihood that 6E goes the way of 4th edition? What's the possibility of current VTT siding with 6E and throwing out 5E? It's two questions,
it all depends
actually.
on how the audience chooses to approach the product. Like, you could make a better version of Dungeons and Dragons. I absolutely believe that's true. It can be done.
Mhm.
So if it is done and there's a different licensing regime and people decide they want the better version of Dungeons and Dragons, and there's something in it which is protectable under copyright law or trademark law or patent law that you can't get unless you agree to some terms from Wizards of the Coast, maybe people will use that thing. But so far, that has not been the case.
Yes, I mean, that's what my lawyers have been saying, is that it's very simple. If they make 6E so good that everyone wants to use it, problem solved. I mean, and it can be done. Pathfinder 2nd edition, in my opinion, is vastly better than 1st edition, and I use it because of that. You could make a better version. People made better, each version of the iPhone. You didn't need to buy a new iPhone, but they tried and usually succeeded in making a better version each time. So people were willing to plunk down more money and get a new iPhone, even though, does my old iPhone still work? Yes, but I want the new one because it's better. There's nothing stopping this.
The challenge is your improvement otherwise protectable by some kind of legal framework that you can ring fence it and say, you can't use this unless you agree to these terms.
Mm-hmm.
So like in 5th edition, they added the advantage and disadvantage rules. You roll 2 D20s and you take the one that either favors you or disfavors you, depending whether you have advantage or disadvantage. Is that protectable under copyright law? I don't think any copyright attorney would say yes. Like, I don't have to agree to a license from Wizards of the Coast to use that mechanic in a role-playing game. I just don't have to. So if that was the only difference between 5th edition and 6th edition, I would just write those rules in my new product and keep using the open gaming license. Like, Wizards has to come up with something that's so novel and so exceptional that they feel like it can be protected by copyright, trademark, or patent, which they could do. But so far, I've never seen it.
Well, on top of that, they're trying to say that 6E is backwards compatible with 5E.
Right.
So that just adds to the fire. Like, why
you could write content for 5E that would work
exactly
with 6E.
That they're trying to have they're trying to have everything. They're trying to. That's why they're trying to invalidate 1.0A, because why will anyone move to 6th edition?
Yeah.
Especially if it's backwards compatible. There's no reason to do it. None.
No reason. Yep.
I have a whole.
So before we move to the next super chat, there was the second half of Chris Moore's question, which was the deplatforming question, which is basically, what are the chances that, say that they don't get rid of 1.0A altogether, but they go to the VTTs and say, hey, we've got a special deal for you. If you just deplatform the 5E stuff and only put on the new stuff that's using 1.1, we'll give you X and such a thing for that.
Yeah, they should totally do that. Like, that's the business I would pursue if I was sitting in that chair at Wizards of the Coast. I'm going to make my virtual tabletop ecosystem so amazing that people will want to be in it. And they will be in it because it's Dungeons and Dragons and it's awesome. Not because there's a license that purports to stop people from making, competitive product, but because the thing that I'm making is just really good. And it is the brand reservoir of all of the equity of 50 years of Dungeons and Dragons, which nobody else currently has access to but Wizards of the Coast. Like, make that product. You'll have all the business. It won't matter if somebody makes a competitive. Okay, let's talk about fantasy heartbreakers, because there's probably a virtual tabletop heartbreaker analogy. A fantasy heartbreaker is a tabletop fantasy role-playing game that is just like Dungeons and Dragons, except it isn't. You've made a few changes to some rules because you think the combat system should be more detailed, or you want to have a new magic system, or you want to have a bunch of special ideas for how characters are created, or whatever, right? But if you take a few steps back and look at it, you would say, well, that game and Dungeons and Dragons are essentially the same game. People have been making fantasy heartbreakers forever. And we call them heartbreakers because people spend their time and energy and money making them, and then they don't succeed. Because if I have the choice between playing Dungeons and Dragons and a game that's just like Dungeons and Dragons, except it changes this one thing that you don't like, most people will just play Dungeons and Dragons because of the network externality. So there's probably virtual tabletop heartbreakers. People will spend huge amounts of money to make a game that's just like the Dungeons and Dragons virtual tabletop, except it isn't. And it won't work because it's not Dungeons and Dragons, and it doesn't have the critical mass of all the people using it. Like, the value is not in the product. The value is in the brand and in the network. The product is irrelevant.
Damn. That was quite an answer.
Yeah, that's an awesome answer.
That was great.
Chris Moore got his $10 out of that.
Oh boy, you got that was the best super chat so far. He's like, thank you. Let's see, what do we have here? We have so many
Matt,
super chats.
Streamers use the
Matt,
fan
yes.
content policy.
Yes,
to
do you want to? You
stream
can
their
read that
games.
one. You can read that one.
And it
Mark.
says fan content can use Wizards IP so long as it abides by the OGL. Will the new OGL 1.1 affect D&D streamers who are trying to use some homebrew in combination with Wizards IP on their stream?
Okay, let's talk about defects in the Open Gaming License. And this is one. The Open Gaming License does not envision a world where people do live plays of role-playing games as a consumable product. Like, we never thought that would happen. The idea that millions of people watch Critical Role is mind-boggling to me. Okay. If I sit down and I play Pathfinder live on a live stream, am I creating a derivative work of Pathfinder? There are arguments that the answer to that question is yes, that you are. Are you prohibited from creating derivative works of Pathfinder by playing Pathfinder live in a live stream? There are arguments for and against. I think the arguments against saying that you're prohibited are much stronger than the arguments that are saying that they are for being prohibited. So in my opinion, you absolutely could do that. I think it's fair use. Your lawyer may differ. Could you use the Open Gaming License in a live stream of a game of Pathfinder? And the answer to that question is yes, you could. You could publish the Open Gaming License at the end of the stream, and your section 15 would reference all this content that you used in that live stream. And you would add at the bottom of section 15 a little note saying live stream, blah, 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 such a date is open game content. And that would be within the bounds of the OGL. It would work perfectly. But people don't do that. They rely on copyright law to say that it's okay to do what you're doing and that it's streaming is fair use. And since there's been no litigation and nobody appears to have wanted to fight and die on that hill, as far as I can tell, there's no concern about using the Open Gaming License to do live streaming. And I don't believe any significant live streamers do it. So I don't see why any change to Wizards of the Coast stance on Open Gaming 1.0A, Open Gaming License 1.0A, would affect people who are live streaming. It shouldn't affect them at all. They are operating under the idea that what they're doing is fair use and is allowed under the copyright law. And they don't need a license for that.
I'm glad you answered that because I get that question a lot. I'm getting that.
Is that what your attorney says?
I didn't ask him yet because I'm not as concerned with that because we're a publisher. And so I've been much more concerned about publishing than streaming at this point. But I'm going to ask him. But I've been getting that question myself. Max asked, Ryan, as a former VP, what is behind such a business decision to go forward with OGL 1.1? Can you speculate on what's happening behind closed doors right now?
Yeah, I can, but it is 100% speculation.
Right.
I walked out of Wizards of the Coast on September 11th, 2001. Weird coincidence. And I've never set foot in the building since. Wow. So I'm just guessing. I don't have any insider knowledge of any kind. I think there are people inside that company who have a vision for a world where they have become a monopoly dominant platform in the way that people consume and monetize role-playing games. And that pathway leads through digital, whether it's a digital tabletop or it's the metaverse or it's some yet to be designed technology. That's that's where they see the world going, that people will leave the tabletop behind, leave paper books behind, leave physical dice behind, and they will move to an all digital environment. And they want to own that environment, and they want to control that environment, and they want to extract monopoly rents from that environment. And that is not a pejorative term. Monopoly rents is just a term of art and economics. It means you get extra money because you control a monopoly. And that's a powerful argument. They're on record. This is a public thing. They spent $140 million buying the Beyond D&D virtual tabletop, 143 million or something, but the number's public, right? Yeah. It's not a secret number. So that's a lot of money. Like, Wizards of the Coast paid a fraction of that to buy TSR. So like, the value of a tabletop that was licensed by Wizards of the Coast was $140+ million at some point in the relatively recent past. That's a lot of money. And if I'd spent $140 some odd million, plus the unbelievable amount of money that Wizards of the Coast has spent over the last 20 years trying to make their own virtual tabletop, I would be looking at that sunk cost and saying, I want to figure out how to get that back, plus a huge multiple on the return. And this open gaming license thing appears to be a thorn in our side that creates the opportunity for competition, creates the venue under which a well-funded, competitive tabletop business could arise to try to break our monopoly. And so let's kill it now. Let's get rid of it before that exists. Like, let's not wait till there's a competitive virtual tabletop. Let's undermine the ability to do it before it even comes into existence.
Yeah, I mean,
that's a business strategy that somebody inside Wizards of the Coast is probably enunciating.
Yeah, I mean, I know they spent $146 million buying D&D Beyond, and the reports are it's somewhere between 250 to 350 engineers, and these are high end. These are not grunts. I know people personally working on this project, and they are very well paid. They are spending a lot of money to make this VTT and hopefully have it come out in 2024. So they obviously are seeing this is the direction they want to go. Again, my opinion. Lord God wrote, what is the legality of tearing down jobs across multiple industries by pulling this license? Anti-competitive? Creating monopoly?
No, not really. I mean, you're talking about a tiny corner of the entertainment industry. It's nothing about this, I think, would fall under any kind of restraint of trade or anti-monopoly activity. It's hard for me to imagine you could make that argument. People lose their jobs all the time.
Yep. Wesley Bruce.
I mean, I don't mean to be heartless about that. It's just the truth.
Yeah. Wesley Bruce said, OGL 1 is all stick. Are they out of carrots? That was it. Tiger Eye said, Stephen and Mark, thank you for taking on this topic with such vigor. Ryan Dancey, thank you for taking your time and for the original OGL, which has made a great community from 1.0 and 1.0A. Thanks to all. Oh, see?
Yeah, that's nice.
That's nice. Severin said, Ryan, your opinion, why do you think they attempted this now? Since third-party content is a drop monetarily, why the draconian push at this moment? The movie?
Okay. So let's talk about Hasbro and Hasbro's valuation. Hasbro's a publicly traded company. They're in the Fortune 500, which means that all their financials are public. You can go online and you can read their financial statements and their annual and quarterly filings about how they make money and what their costs are and all the things about their business. And they are required by law and by the SEC, which monitors them, to make full and truthful disclosures of all that information. And they have. And I would never want to suggest that Hasbro or anybody at Hasbro has done anything illegal, because in my opinion, they have not. What they have done is not talk about Wizards of the Coast for 20 years. So I used to listen to the Hasbro earnings calls where reporters with access would be allowed to ask questions of the Hasbro executive team. And those calls were always about G.I. Joe and Transformers and My Little Pony and whatever the movie of the year was that Hasbro was trying to do. After a while, it morphed into questions about what's Hasbro's strategy about buying these digital platform companies and entertainment businesses. Lots of questions about lots of parts of the Hasbro conglomerate. What they never asked about is where the money came from. So I know personally, and I know anecdotally, that a significant percentage of all of Hasbro's profits come from Wizards of the Coast. And by significant, I mean maybe half. And you would think that where does half the profit come from would be something that analysts and shareholders would be deeply interested in about Wizards of the Coast. But because Hasbro just doesn't talk about it for 2 decades, basically nobody really understood that. And they would instead be curious about what the new G.I. Joe release was, or what Michael Bay is going to do in the next Transformers movie. A couple of years ago, a hedge fund dug into that data. And that hedge fund came out the other side and said, holy crap, everything you think you know about Hasbro is wrong. And they published a very detailed PowerPoint pack called Free the Wizards. And the argument in Free the Wizards is that if Hasbro spun Wizards of the Coast out into a standalone publicly traded company, the value of that company would be equal to the value of Hasbro, which means that currently Hasbro is worth nothing. That the total value of every single thing inside Hasbro except Wizards of the Coast is 0. Let that sink in. Now, that's probably not true. What would actually happen if you spun Wizards of the Coast out into a standalone company is that Wizards would immediately be valuable, probably as valuable as Hasbro. And Hasbro would not be worth nothing. Hasbro would be worth probably what it's worth right now, maybe worth a little bit less, but some number within striking distance of its current value. So Hasbro shareholders, who would be the recipients of the new shares in the spun out Wizards of the Coast, would double their money or increase their value by a substantial margin, right? Huge amounts of money would be effectively created out of thin air by making visible the fact that Wizards of the Coast is such an incredibly valuable and profit-generating enterprise. Well, ever since Freeze the Wizards was published, now people in analyst conference calls are asking Hasbro a lot of questions about Wizards of the Coast. And they want to know things like how much of the profit at the company is being generated by games like Magic the Gathering and Dungeons and Dragons. And now that those questions are being asked, the answers to those questions affect Hasbro's stock price. So they are now, by the ironclad logic of the stock market, they have to show shareholders that they are increasing the profits from Wizards of the Coast. They cannot escape the logic that if the company was Hasbro, if their profitability is based on Wizards, that in order to increase profitability, they have to make more money from Wizards of the Coast, which is why you have things like senior Wizards of the Coast executives saying on the record, we think Dungeons and Dragons is under-monetized. Under-monetized just means we would like to make more money from Dungeons and Dragons. That's all it means. And they're going to try to find ways to do that. Well, are they going to sell a lot more books? Boy, that's a hard argument to make, isn't it? Is there really that many more D&D books you can sell? Are they going to innovate a whole new platform? Are they going to go back into novels and start publishing million-seller Harry Potter level novels? Boy, that's hard to imagine, isn't it? I don't see that happening. What are they going to do to show that they're growing the D&D business? The only answer that any rational person is going to accept is digital. They're going to show the world that they're going to make a play in digital, which is going to somehow, magically, through the magic of digital, make a huge new revenue stream and massive new profits from digital. So obviously there's people inside the company who have a lot of pressure on them right now to say, figure that out, make as much money from digital as you can, make our strategy look real to shareholders. Well, one thing you can do, you can take steps to try to force people onto your digital platform. And that's what 1.1 looks like. And that's why it's happening now. Because now is when the pressure is being put on those people.
I think that might have been the best answer I've ever heard to a question in my life. Wow. I'm almost in tears here. That is so well said. And it's funny because one of our past shows, I went through the quarterly statements and the earnings reports to show how Wizards and Magic was never in them, even though they were making so much money. And then just recently, are they starting to put into terms Magic and Wizards, and then very recently Dungeons and Dragons, even though they've had this property for 23 years and was making tons of money.
There was a time not that long ago, I'm going to say maybe 10 years ago, when there was a strategy inside Hasbro they called core brands or key brands or top brands or something like that. Mm-hmm. And the idea basically was that they were going to divide the company into things that really mattered and things that didn't. And they just picked a number and said $50 million. If a brand generates $50 million a year in revenue or more, it's going to be a key brand. And if it generates less than $50 million, it won't. And we're going to put all of our time and attention into our key brands. We're going to double down on the valuable stuff. And D&D didn't qualify. So not that long ago, D&D made less than $50 million a year. It was not a meaningful part of Hasbro's business. Magic the Gathering has always been a key brand, but D&D not so much. But boy, I have been told things in the last 2 weeks that shock me about how big the D&D business is today. Unbelievable numbers. If you had come to me in 2000 and I walked out of the Dirty Diaper meeting and somebody said, Ryan, in 22 years, how much money is D&D going to make in a year? I would never have said that number. Like it's an impossible figure that they're making as much money as they're making. It's inconceivable to me that it is true, but people I really trust say it's true. So now D&D is a core brand, and now Hasbro cares.
And it's all because of you and the OGL 1.0A. Okay, it's not all because of you, but it is a gargantuan reason.
I don't want to claim that that's true, but now I'm going to tell you why I think it's true. So,
it's not true, but I'll tell you why it is true.
Let's talk about 4th edition. So 4th edition is a game that people that I very much respect, who are game designers, believe is a incredibly well written piece of game product. It's very good as a game. It is probably the world's largest fantasy heartbreaker. It's just like D&D, except it isn't. And what happened with 4th edition? 4th edition came out and its audience said, I don't want that. And they looked around and they said, well, I could do this Pathfinder thing. And the people at Paizo basically said, yeah, that's the strategy. We're going to keep selling you the game you want as long as you want to buy it. We're going to keep making a variation of the 3.0 engine, and it'll be roughly compatible with most of the stuff on your shelf, and you already know how to play it. So do this. And you know, that thing we talked about before about social networks and network externalities, in the blink of an eye, it shifted from 4th edition Dungeons and Dragons to Pathfinder. The audience, the network, just kept playing the same game with all the additions and new rules and benefits and all the content that Paizo was creating for Pathfinder. Pathfinder was a great product. Like, I'm not trying to say that it wasn't. It itself is a great product, right? Okay. What happens if Pathfinder doesn't exist? Which means, what happens if the Open Gaming License project never happened and there is no Pathfinder? That the day that 4th edition comes out, that's it. You get 4th edition, or you just keep playing your old 3rd edition books that are sitting on your shelf. Those are your choices. I would argue what happens is that people stop playing Dungeons and Dragons. They go play World of Warcraft. They go do something else that was really popular in 2007. The social network of Dungeons and Dragons starts to contract, just like it was contracting in the late 90s. It gets smaller and smaller and smaller and smaller and smaller, and it could go all the way to 0. Who knows? It's counterfactual. We don't know, right? What actually happened is that after trying 4th edition for a bunch of years, Wizards said, okay, I guess we were wrong, and we're going to stop making our fantasy heartbreaker, and we're going to go back to making Dungeons and Dragons. We're going to make 5th edition, which is really 3rd edition, with a bunch of rules cleaned up and a couple of new game mechanics and an emphasis on templating and a lot of good stuff that, like, I don't want to dismiss it. They did a great job in 5th edition, right? But 5th edition and 3.5 are brothers from another mother. Like, they are right next to each other on the tree of life. And that's where Pathfinder sits. And because Pathfinder existed, and because Pathfinder kept all those people in the hobby and still playing that game, when 5th edition came out, Wizards wasn't starting from, let's see if we can get all these people to return to the table. They got to say, let's say if we can get these people to come back to Dungeons and Dragons, the place they want to be anyway. And they did. So Open Gaming License probably made 5th edition massively more successful than it would have been if it didn't exist, because Pathfinder was a reservoir for those players during the 5 years that 4th edition was failing.
I know, that's what I mean, as someone who actually played 4th edition and went from level 1 to 20, believe it or not, I loved 4th edition's combat, hated everything else, but it was an incredibly elegant, wonderful war game. Yep. But when Pathfinder came out, we went right to Pathfinder. And, you know, we played one campaign of 4th, and that was it. And when 5 came out, we were very excited. And I played it right away. I bought, was it Lost the Mind, was it Delver's Mine? I forgot the name, but the very first adventure. And yeah, I mean, that kept us in the hobby. And if it wasn't for Pathfinder, we probably would have. We were playing a lot. You know what? We were doing both. We're playing a lot of World of Warcraft and EverQuest and playing D&D, you know?
Yep.
So it's
Yep.
possible.
Yeah, I think a lot of people did that. Yeah,
Yeah,
for sure.
yeah.
Yep.
I have a few more. We got tons here. VTT Advisor. When and how did you come up with the idea of open sourcing D&D? Was 3E designed with the OGL in mind, or vice versa? That's actually an interesting question.
No, it wasn't. There was no part of the design of the game that was influenced by the desire to be open.
Oh, okay.
In fact, D&D was influenced way more by Magic than it was by anything else. One of the things that Magic the Gathering taught the gaming industry is the importance of what we call templating, which means when you do a game rule, you should write it the same way every time you write it. So first and second edition are not templated. They are very ad hoc. The same kind of rules written in many different ways, which creates an endless amount of interpretation issues, right? Third edition, and 3.5 in particular, was heavily templated. The objective was that every time a rule was used, it would be written in the exact same way, so that there would be far fewer of those interpretations and problems of understanding how the rules are supposed to work. And that came out of Magic the Gathering, because in a trading card game where you only have this much space to write a rule, you better write it correctly every time, or the people who want to break those games will break it.
No,
but there was never a time when we sat down with the R&D team and said, so we need you to do this thing so that we can make this an open source game system. That never happened.
So by the way, we have 3,100 people watching this live.
That's right.
And only 900 likes. Come on, guys. Help the algorithm. Help it get out there.
One of the things I'll say also is that there was actually a little bit of a problem when we did the system reference document for third edition.
Oh, okay.
Because there are some parts of Wizards IP that are embedded in the rules for Dungeons and Dragons that we did not want to lose the copyright or trademark interest in. So there's a bunch of spell names that have the names of characters in them. Mordenkainen's disjunction, right?
Mm-hmm.
So we had to fix that. When we released the system reference document, we went through every single word and removed anything that we thought was a valuable, protectable part of the intellectual property that we owned and didn't want to lose control of. So that's why the third edition SRD has Mord's disconjunction, not Mordenkainen's disconjunction. And there were some things about gods, and there were a few monsters that we carved off and said, we're not going to let that go into the world.
And Tensor's disc and all those.
And the Mind Flayer.
Right.
I actually have a question about the Mind Flayer. I've always wanted to know the answer to.
Here we go. Here's your chance, Mark.
What
you may not like the answer.
No. Like, what is the provenance of the fact that like Final Fantasy 1 has a Mind Flayer, has had a Mind Flayer, and just continues? Final Fantasy continues to put in Mind Flayers. Like, how does that interact with the fact that they're one of the ones that are withheld?
Yeah, that's the question that you're not going to like the answer to. Nobody knows.
Okay.
Where did Mind Flayer come from? Nobody knows.
I wasn't even wondering exactly where it came from. I was wondering what is the not the provenance of the Mind Flayer as intellectual property, but the provenance of like the state of the Mind Flayer as copyrightable, given that a video game company has been using it for a very long time without it being challenged.
Nobody knows.
Nobody knows.
Would I use it? No, I would not.
Neither would I, but it's very interesting.
Yeah, there is a handful of stuff that we just could not find any way to determine the provenance. I mean, there's some weird stuff in D&D, like the Rust Monster is based on a bizarre plastic dinosaur figure that was available in the 70s, which is like some weird like idea of what a dinosaur is that isn't even a real dinosaur. Yeah, there's weird stuff like that in D&D, but you could source a bunch of it, back to the early days. There were articles in Dragon Magazine and commentary that was available at the time where you might be able to figure out why something is the way it is. If you go back and look at any of the 80s, news groups and things, endless discussions about what a drow is and how you should even pronounce the word drow. But Mind Flayers, Illithids, couldn't source the provenance. No one else had really done anything with them. They are an iconic D&D monster, and we just said, screw it. We're going to keep it. Like, the D20 environment is not going to be affected negatively if you can't put a Mind Flayer in your adventure. Like, there's lots of other things you can use instead.
So we have
Yuan-Ti, I think, is on that list.
Displaced
Beholder, Displaced
so
Beast.
It's just in the midst of time, right? And look, I mean, it'd be awesome if somebody would sit down and do the research and figure it out. Like, I don't know if it's even possible. So a lot of those guys, unfortunately, are dead. But maybe it could be teased out. I don't know. Ben Riggs, if you're listening, get on it. Figure out where the mind flayer.
So let's crank through some of these super chats. Juan Ravos wrote, couldn't new works going forward just split out troublesome sections into separate works, i.e. the main book with no system-specific content and system-specific content in a separate booklet? So basically taking out the SRD and then not using OGL, which I think a lot of people are trying to do now.
Are you asking if you can publish a source book for a role-playing game that doesn't have any game mechanics in it?
Sure.
I think maybe
that's called a novel.
Yeah,
maybe like an adventure that
Yeah.
didn't have the game mechanics, and then like a second book that is like the that might be even in multiple systems, right? So you have the adventure with no mechanics that it just says there's a Blarglin monster in there. See this page of our other things, and then in the 6e in the version for D&D. Published under 1.1, it has stats for a Blarglin in 6e, and then in a Pathfinder, maybe they have stats for a Pathfinder version of it, but they're all in separate books.
Yeah, I think you could do that right now. I mean, I personally, my opinion is yes, you could do that. Why does nobody do it? Because it's an illegal gray area, and therefore it's freaking dangerous.
Tolscan wrote, Ryan, am I mistaken or WotC trying to update the OGL in a way that invalidates 1.0a instead of simply revoking it? Also, there's a really fitting quote about monopolies in The Godfather of the book. So
let's say this, and we probably should have started this show off with this 2 hours ago. Until they do it, it isn't done. They haven't done anything yet.
correct.
There's a bunch of rumors and there's a bunch of leaks, and there's a very little bit of commentary from them about what they think they're going to do, but they haven't actually done anything yet. So we can talk about what we think they're going to do and what they've told people they're going to do and what they've shown to partners in terms of licensing, but they haven't actually done it yet.
Mm-hmm. Yeah, we were talking about that earlier, is that this is all speculation.
Yeah.
Important
It might not
speculation.
happen.
Right.
If they stop.
Right. If as long as they leave and they try not to revoke 1.0a, they can do anything they want. They can make 1.1 as draconian and horrible as they want. They can give everything away from free. Does not matter. It all comes down to that.
They could come back at this and say, we got a tremendous amount of feedback from the community, and it's obvious we need to do more work, and we're going to spend 6 months, and we'll come back and talk to you in the fall. And maybe in the fall they come back and they've got a better offer. I don't know.
Yeah, we don't know.
Yeah.
Sam Rochter, thank you for all your amazing work in getting information out there. Without people like you, we would lose everything. We can't let corporations drain dry such a wonderful community project that D&D has been up to this point. There you go. Stephen Rennie writes, what happens when WotC publishes under OGL 1.1?
Nothing. They probably will never publish under 1.1. They don't have to.
Yeah, that's actually true.
So, okay, let's talk about that.
Okay.
They should. I really hope that they would. Like the Cathedral and the Bazaar, which is one of the fundamental reference documents of the open source movement, written by a guy named Eric Raymond, talks about his experiences in open source software development. And one of the things he talks about is that when many people have their eyes on the source code gets better. And one of the things I hoped would happen is that the open gaming license would create a renaissance of new content that would in turn be brought back into Dungeons and Dragons to make Dungeons and Dragons better. That instead of having to do all that work themselves in the cathedral, to use the Cathedral and the Bazaar analogy, wizards would get to go to the bazaar like everybody else, and they would add open game content to their products. I think they did. I think there's a couple of products that they published that had open game content in them, but they don't. It's not their thing. And I think that's something of a tragedy. I really wish that had happened.
Interesting. Let's see. Marcus Katz writes, thank you, Ryan, for reminding us the spirit of our game over the last 50 years. And thank you, Stephen and Mark, for putting this together. Again, very nice. Thank you. Bromos Sunstar Ranger. That's a good name. Isn't WotC going to court in October against new TSR Justin Lanasa? That case could answer a lot of our questions, right?
The trademark case, I think.
Yeah, that's a trademark case. Yeah. I mean, I actually have been following it, and I think that's completely different. That's a fight over using the terminology of TSR.
Yeah, I think, I mean, there's a lot of weird stuff there that I don't think is going to be applicable outside of that particular case.
Yeah. Minecraft Dragon version 2, gave us $5, and that's it. Thank you. And Jardin F gave us some $1.38, and thank you very much. Forlin Knight said, on the topic of video guys. Oh, okay, here we go. I'm the one who started this, so we got to answer this. On the topic of video games, did you guys talk about the KOTOR, Knights of the Old Republic, using the SRD separate already? I'm the one who made that meme, so we should probably answer that. That's me.
To you.
Well, that was you.
Yes,
Okay.
I'm the one.
Well, I'm going to call you to task, sir.
You were
because-
wrong, Steven.
Well,
Sure,
I thought
Ben.
it was based off of modern D20, and that's actually what's in the Wikipedia. And I did go through and download, and I still even have the instructions in my attic, trying to find if the OGL was in the manual, or if it was anywhere, but I didn't see it. But it was more of a thought exercise. I did not expect this thing to go viral. It was more of a thought exercise of the concept. It was more to try to get this in front of people, because it's like, according to the new license, maybe it doesn't work now, but more importantly, Lord of the Rings is coming out with their 5e book now. And according to the new 1.1, I know things are trademarked and you can do a wall between what is open and what's not open, but it's still, why would people want to, with their million or billion dollar licenses, publish under 1.1 with that language in there saying, oh yeah, we can just use your stuff forever for free? Why would anyone even take the risk?
Let's talk about Knights of the Old Republic, because I think that's a fascinating story. Okay, so I've done some really interesting things in my life, and one of the interesting things I've done is I was a Star Wars licensee.
Cool.
I went down to Skywalker Ranch, and I brokered a deal to license Star Wars for Wizards of the Coast for trading card games, role-playing games, and other products. And when I say I mean I was in the room. There were a lot of other people in the room who got that deal done, including Bill Savasek and Brian Lewis. Cindy Rice was there, and I think Lisa might have been there too. Anyway, we got that deal done. So Lucasfilm Limited, LFL, which is kind of the umbrella entity that controls a lot of the Star Wars stuff. They have a pretty long experience with IP development. Them and Disney may be the two companies that have the best understanding of what it means to have a brand and not have just a movie. And so they have been through the ringer on Star Wars licensees down through the years. And some of their licenses have been really bad, and some of their licenses have been very problematic. And they did role-playing game licenses. They did a license with a company that was called West End Games to do the Star Wars role-playing game, which is a critically very well-received game, and it sold a lot of units, and it's a very good game. Bill Savasek actually got to start in role-playing game design working for West End, and he worked on the Star Wars role-playing game for a long time. That company went out of business. I don't know if it technically went bankrupt, but it ceased functioning for a long time, and they didn't publish Star Wars for a long time. They lost the license or whatever. And so if you went to Lucasfilm Limited, LFL, and said, hey, we want to do a Star Wars license, and we want to use all that cool content that West End Games made, Lucas would say, well, there's issues. Like the license that we had with them didn't clearly say that we owned everything in those books. It was a traditional license where we owned the parts of the intellectual property that we own, and they own the parts of the intellectual property that they owned. So there's some questions as to who owns what in the West End Games role-playing game line. And when we went down and negotiated for game rights from Lucas, they were very clear that that was not going to happen with us, and that we had to give them, as a part of the license for Star Wars, a perpetual license to the role-playing game material, the game engine. And that's in the contract that we signed with Lucas. So we got that deal done in, I want to say late 2000. Trying to remember what the weather was like. I'm going to say late 2000. And I left the company in September of 2001. And work on the Star Wars game was ongoing throughout that whole period. And work on Knights of the Old Republic was ongoing at BioWare during that period. And if anybody had come to me and said, how are we going to honor this obligation we have in this license to give them a license to the game, I would have said, well, they can use the open gaming license. Like, everything that they care about is in the OGL, and we'll do a system reference document for Star Wars, and they'll have all the game mechanics. But that apparently is not what actually happened. What actually happened, according to Bill Slavicek, is that Hasbro and Wizards and Lucasfilm Limited worked together and with BioWare so that all the content that's in Knights of the Old Republic was authorized under an agreement between the parties. And they didn't use the OGL. They're not bound to it. It's not a part of that project at all. It's just a thing that exists between the various people, the various companies involved, which is not that uncommon. I mean, it's a pretty common thing. It's a weirdly uncommon thing to have multiple peoples with big IP value in the same deal working with a third party, BioWare, but it's not that weird. So they got it done. And since that's what was happening, anything that was happening inside Wizards of the Coast was probably communicated to BioWare so that BioWare could put it in the game. So I'm sure there's things that are in D20 Modern and the Star Wars role-playing game and lots of other things that Wizards worked on that show up in Knights of the Old Republic for the sequel. But none of that content is open game content.
Interesting. So sorry, everyone.
No, that's all right. Okay. So then the next question was: so if I am Tolkien Enterprises, why in the world would I ever allow Lord of the Rings to be enmeshed in this nonsense?
Yeah, that was
right.
my
Well, the answer
question.
to that question is that the open gaming license is very good at allowing you to mix material from different sources and preserve and protect the underlying intellectual property rights embodied in all those various sources. That is the purpose of the product identity clauses in the open gaming license. You can ring fence off that stuff and say, this content is just not open gaming content. You can't use it without a separate license. So it's completely safe to publish a open gaming version of a role-playing game that is using the intellectual property that is embodied in Lord of the Rings. It's completely safe. Tolkien has no risk of losing control of their copyrights or trademarks. Even if Wizards changes the licenses, that is not going to change, because in the worst case scenario where they try to assert a bunch of stuff was true that isn't true, normal copyright and trademark law would apply to protect Tolkien Enterprises against infringements of their intellectual property. And if it's protectable against Sally, who doesn't use the OGL, it's completely protectable against Dave, who does.
Well, I just find it fascinating that Lord of the Rings, literally the 5e version, is coming out in a few weeks or months.
Right. Sure.
And according to Wizards, on Friday, the OGL 1.0a is invalid and you have to use 1.1 or you can't publish anything and make money off of it. And oh yeah, here's all of our stipulations that you have to now abide by. Yeah. And as you said, if OGL 1.0a wasn't so bulletproof and have the fencing that it does to protect billion-dollar IPs, that no one would use it. And you can't just, the whole reason is you can't just have someone just invalidate it like that.
Ryan, you were saying that even in the worst case that Tolkien would be safe, but let's say that the worst case happened, 1.1 came out and a judge was like, oh yeah, that's totally legit, and you published it after the 13th, so you were under 1.1 whether you like it or not, and 1.1 says it does not have the fencing. It does not say that you can separate out product identity. It just says Wizards owns everything that's in this. Would Tolkien still be okay?
Yes, because Tolkien is not a party to the open gaming license. The publisher of that role-playing game is party to that license. And they cannot convey rights to something they don't own to a third party.
Interesting.
So Wizards could sue them and say, you can't publish that book. If Wizards tried to say, we changed the terms of this license, now we own Gollum, Tolkien would say to Wizards of the Coast, see you in court. Like, it's an untenable position. It cannot be possible for that to have occurred.
So what you're saying, essentially, I'm going to try to boil it down, is that what would happen is that the game company would try to publish, because they have a license with Tolkien, and Wizards is saying they're under 1.1. Wizards would come to them saying, listen, under 1.1, we have to be able to own everything that's in your book forever and do whatever we want. Or not own, you own it, but we can do whatever we want. And since it has this stuff from Tolkien that you don't own, we will not be able to do whatever we want with it. Therefore, ergo, any licensed content that has another IP is automatically violating 1.1 because you can't give it to us legally, and therefore you can't do it.
Yeah, that's an argument that they could make. That's one of many arguments they could make. Yes.
Okay.
Yeah, for sure. For sure. It's also possible that Tolkien could go to that company and say, you don't have the rights to publish that book, and we don't want to be a part of that lawsuit. Mulch it.
True. Victor Perez said, to your knowledge, is there any concern at WotC that people will retaliate to 1.1 by just pirating books and playing offline?
Why would they not do that now?
Yeah, I mean, there's nothing preventing anyone from doing that, but the whole point is I think most people want to support the community, and more importantly, if you have the books, and a lot of people want to play online now. I mean, I haven't played offline in almost 11 years, except at conventions, unfortunately, and that's just because all my friends are all over the country. And after COVID, this is where, for better or for worse, a lot of people are playing is online. So, I mean, you can do that now. There's nothing stopping you. Vero,
look, I don't think any company ever believes that there will be a revolution, that their customers will fight back against the man.
Right.
Like, it just doesn't happen. It's nothing that anybody writes into a business plan. What if the community goes into open rebellion against us? It's not a concern that anybody's going to write into a business plan.
They always assume here's the worst case scenario is we only make this much money, and the best case scenario is we make this much money. Like, there's no. That's
exactly right.
They just look at the high and the low. They don't think of it not working.
Yeah, that's right.
Vera Offroad sent $5. Thank you. That was it. David Portis, thank you for all your videos on OGL. Great to hear from Ryan. If you guys had to guess, do you think the most likely scenario that this was a scare leak to persuade everyone to agree to a final 5% royalty? No, I will answer first because I know for a fact this was on contracts of many people I've been in contact with, and they were expected to sign this very soon. This was not a scare tactic. This was not a leak. This was not done on purpose. This was it. And I also know from private contracts that other people have gotten, they had different amounts. Some people got 20%, some people got 15%, and they had things in there that they would get promotion and a lot of support from WotC and Hasbro. So that's one of their reasons that they would sign it. But 15% was still way too much, and they did not sign it.
Any percent is too much.
And
Open content licensing doesn't work if there is friction. It has to be a frictionless experience.
Vera Offroads, another chat, says, seems to me at this point, even the suggestion they're going to try to pull this off is enough to create another source to play with. All they said. I know that's the problem. Walter Starr sent a super chat. First appearance of the Mind Flare in print was Volume 1, Issue number 1 of the Strategic Review from pre-Dragon OD&D days. Ooh, so people are on the case. You might have set off a chain reaction there as you got geeks trying to find out the providence of the Mind Flayer.
Well,
there
I mean,
we go.
that's where it appeared in D&D, but the question was like,
where did it come from?
That's your challenge. Are you laying out a quest for everyone, Ryan?
Yeah, like it had to have been in a homebrew campaign, but was it a situation where somebody said, I've imagined this race of squid-headed dudes that are powerful, or is it, I found this thing in a 1930s pulp comic book that looks awesome, and I'm going to literally, how do you prove where it came from? Sometimes you can prove. Sometimes you can say, oh, yes, I invented this thing in this work that I made. But yeah.
Well, that reminds me of the origin of zombies is from the Smurfs. I don't know if you know that, way back when, from 1969 or something, there was a whole story about zombie Smurfs, and that's where the concept came from. So who knows?
It's from an African, a 1800s.
Oh, it's been around forever. Yeah. But it was the first time in modern print publication where it was kind of it's everything. You go back far enough, you'll find something. But that my point is,
look, there are things in Dungeons and Dragons, in any fantasy property, that are unsourceable. Where did giants come from?
Right.
You can't source it.
Well, we talked about dragons.
We talked about
even in world myth, you can't source giants because what would you source? See, right? The Gigantes from Greek mythology are the direct name, but you have Jotun from Norse mythology. They're everything.
Yeah. So there's lots and lots of things just can't be sourced.
Yeah.
And you just have to shrug your shoulders and say, we'll never know. Yeah. But nobody claims ownership of those things.
T.A. Hawkins said, has WotC already caused significant damage with 1.1?
Oh, I think the answer to that question is yes.
Yeah.
I mean, their stock price has been battered all year, but it has not gone up since they started making these announcements.
Minecraft Dungeon version 2 said, What do you believe will happen next in the future of this situation, and what do you believe will happen to the community and the company? Oh, that's a big question.
Well, a big part of me hopes that it doesn't happen. There's a big part of me that hopes that there's a faction inside Hasbro that's saying, don't do this. It's all pain and no gain. Just stop. And they somehow are able to get enough leverage to just put the brakes on, and it doesn't happen. That's what I hope happens. I don't think that's the likely outcome, but it's not a zero chance outcome. I would say the likely outcome is they go ahead and they do it, and then it's a big fizzle. And they're getting sued, and there's nobody taking them up on the offer, and their shareholders are complaining, and the Wall Street Journal's writing articles about why are they doing this, and things are bad for them for some time. And by bad, I don't even necessarily mean economically bad. Like, it might just create a lot of buzz and interest in Dungeons and Dragons, gets a lot of people to buy the books and start playing the game. It's hard to imagine that there will be a positive long-term outcome if they do it.
So I will say, if you want to super chat, get it in now, because we can't do this forever. So I do want to say we're going to stop them soon. Daniel wrote, which words are free to use in your own TTRPG without OGL and legal issues? For example, can I use the words strength or arcana?
Talk to your lawyer.
There you go. Severin wrote, opinion or option, Hasbro using silence to use this time to stranglehold and keep people waiting from publishing new items. No cost for litigation or contract breach. Because a lot of people have been in a holding pattern. That's me. So that's just, what do you think of that option or opinion that's happening?
I don't think they did this to stop people from publishing for 3 weeks.
Yeah.
Like, that's meaningless to them.
No.
That's the effect. That's not an intention.
Yeah. Wolfpack 6, 2 questions. 1, does the new OGL impact indie games offered publicly at no cost? That actually is an interesting question.
Well, they haven't published it, so we don't know for sure.
Right. But so, we don't know. 2 is how are retro clones such as DCC, OSRIC able to be created? So
that's a great question.
Yeah, how are like DCC able to be created under OGL?
Yeah. So that was an unexpected development. Okay, so first and second edition Dungeons and Dragons have core parts of the game which are not the result of an algorithm, a process, or a system. The charts that tell you if you hit an armor class were not derived by writing a function and then printing the output. The values on that chart were calculated by hand and then adjusted by hand because Gary thought they should be a number that he liked better than another number. That's art. That chart is probably copyrighted. I mean, it is copyright, but it's probably a relatively strong copyright. There's a ton of laws about accounting systems, and I don't want to get into it, but it's interestingly different than THACO or than the third edition mechanic of D20 plus modifiers versus a target number. The first and second edition charts are art. Saving throw charts, the same way. Experience points per level when you level up a character, same way. They're arbitrary. And arbitrary is good for copyright. Copyright arbitrary. So the emergence of the retro clones was kind of a surprise. How did they do it? Well, I'm not a big part of that scene, but my understanding is that they were able to cobble together most of what they needed from existing sources in the various system reference documents. I know that there was some work done to get Wizards to maybe publish a few things in a few books that they would then put in a system reference document that would help the retro clone guys. And I think that was done in 3.5, although I really wasn't a part of that. I didn't pay much attention to it because it seemed really harmless to me. So I think it's just really creative work. And I think that the fact that there hasn't been any litigation in that space and that nobody has gone after any of those projects or even seemed interested in going after those projects is probably an indication that they did a good job and that there really wasn't enough meat on that bone to gnaw on if you're a lawyer. And the whole idea that there is this huge market for first or second edition Dungeons and Dragons or OD&D, basic D&D, if that market existed, then there wouldn't have had to been a third edition in the first place. So it isn't like Wizards felt like a huge revenue stream was being drained off of the back end of Dungeons and Dragons. Like it's a fan project run by fans with a some level of commercialization, but nothing I think that rises to the level of concern that anybody at Wizards probably would ever have. And I think there's maybe a sense of appreciation that it was a hard thing to do and they did it. So kudos for doing that thing that is hard. Yeah, there were very few things that surprised me, but that one was a surprise. So
we are getting a gargantuan number of chats, so I'm going to go through them very quick. Let's see. Andy Alman wrote, if I am working on a project that is incomplete, should I publish what I have on Thursday so that I can claim it came out before 1.1? Guess that's your I know that's their decision. I mean, I don't think 1.
Can't give you legal advice.
Yeah, and 1.1 it's not out yet, so it doesn't matter as of right now. Wesley Bruce said, trying to monopolize VTTs will get shut down by the EU, etc. Not all VTTs are American. That's something that has been interesting because we are talking about American law, but European law is very, very different. Is there any opinion you have on that, or not really? VTT Advisor, if not for 3E, when and how did you come up with the idea of OGL and open sourcing D&D? I think we covered that in the beginning mostly.
Yeah, I feel like we talked that.
Yeah, we did talk that through. X-Tech wrote, can Ryan tell us, you don't have to answer this, but a lot of people have been asking this, why you left Wizards of the Coast?
Oh, that's an easy thing to answer.
Okay.
Yeah. So Pokemon happened.
What?
Everybody forgets this, but at the same time we were doing 3rd edition Dungeons and Dragons, Wizards of the Coast published Pokemon. And Pokemon became the most successful hobby gaming product in the history of the world. And its revenue and profit was it dwarfed Magic, and Magic dwarfed Dungeons and Dragons. So my team and I had worked really, really hard on a really hard task. And I think we had succeeded far beyond anybody's expectations. The dirty diaper meeting was figure out what went wrong, fix it, and make money. And we did all 3 of those things. And I think the team earned every bit of kudos it got for doing that. And it didn't matter at all. The company was making so much money from that little yellow rat that no amount of dice chucking was going to have any meaningful impact on the company at all. I'm also a big believer in giving people the opportunity to grow. And the way the organization was built at the time, there was no place for anybody to grow as long as I was in that seat. So I went to Vince Calori, who was the executive vice president, and basically was essentially the person who ran the company. Peter was the CEO, but Peter was more involved in, at that point, dealing with top level strategy and conversations with Hasbro and a bunch of other stuff. But Vince was the guy who made day-to-day management decisions. And I said, look, I've done this thing and I feel like we've succeeded and I feel like we've roasted a challenge and I want to know what my next role is going to be at the company. And he said, well, Ryan, I think you should look outside Wizards of the Coast for your next position.
Oh.
And so I did.
There you go. So it was a simple question. I do remember that. I lived on 23rd and 5th, right across the street from the toy building. And when Pokemon was released, they used to do these chalk drawings on the sidewalk when people were walking outside in the trade show. And there was a big, gigantic chalk drawing right in front of my apartment that had Mario welcoming Pikachu. And it says, "Welcome to the family, Pikachu." And I remember seeing that. And I was like, oh, what's that? And I always think about that. I was like, wow, who knew? And that was not that long ago. As you said,
that license was done in 1998. And Pokemon really got started in 99. And by 2000, it was all that in a bag of chips.
Yeah, that's when it was, 99. I remember seeing that. I was like, oh my God, it is. And it still is the number one property in the history of the world of all time, which people can't believe. It's more than everything else by a lot. Let's see. Steven, did you ask about the quotation and where it came from? Yes, we did. Way at the beginning. It was the first one.
Yep. It was Brian Lewis, the lawyer who drafted the OGL.
Jeremiah said, have retro clones ever been produced by the OGL?
I don't know what that means. There are retro clones. They use the OGL.
Yeah,
Yes,
so-
The
yeah.
question was, have they ever been protected?
Oh, sorry,
by the
protected.
OGL?
Sorry,
That's
have
what
they
the
ever been
question asked.
protected by the OGL?
And they
Sorry.
use the OGL, so they gain all the benefits and
Mm-hmm.
that using that license does.
Yep, someone has some interesting Wizards of the Tower publication history. Mind Flayers were created by Gary Gygax, who said that one of his inspirations for them was the cover painting of the Titus Crow book, The Burrowers Beneath, by Brian Lumley.
There you go.
There we go. You see, you get some geeks on a task, and they will go to it. By the way, don't forget, do like and subscribe. We got 3,200 people watching and only 1,800 likes. That means 1 out of 2 of you ain't liking this thing. Squatch Hammer. Would you say this would create a new explosion of TTRPGs that would shake the established business for new industry giants to be created? I presume they're talking about if something like OGL 1.1 in its current form will shake up the industry and perhaps cause and create another Paizo.
Well, and look, the industry is in a lot different position than it was in 2000. It's much, much, much healthier than it was. So I just don't see it. Like I don't see there being some massive new renaissance in gaming because the license is bad.
Mm-hmm. Stephen Power, very hypothetical. If 1.0A is invalidated in court, could a version of 1.0A be drafted under another entity like OGF, for example? Just curious.
Yeah, but it doesn't do any good if there's no content license. The value of the open gaming license is that it licenses Dungeons and Dragons, not that it's a good license.
Mm-hmm. Initiative Coffee wrote, will this have an impact on use of D&D for public events like convention play, sold seats, and I need my glasses.
Therapeutic
use
of D&D by mental health professionals.
Yes, thank you, Mark.
Yeah, I can take these.
I guess it all comes down to how aggressive Wizards tries to be about using the powers that they think that they have. Look, Marvel went after a little kindergarten for painting a picture of Mickey Mouse on the wall. So there's no limits to what you could do. It's just whether you want to do it or not.
Friendly Zerl 1.1 rumors are fragmenting third-party publishers into small cliches. You do it, Mark. I'm getting tired.
Okay. 1.1 rumors are fragmented third-party publishers into small cliques around proprietary systems. EOTC will divide and conquer to funnel players into the Wizards' walled garden because the community will be divided. That's what said it. There was no question. It was more of a statement.
More of a statement. So I do want to do this forever, but we obviously can't. But I mean, I do have a little bit more I want to discuss. One thing, by the way, we over here at Roll for Combat, we use the OGL 1.0A, and I will be completely honest. I myself was not as familiar with the OGL. I knew about it, and I would always see it in the back, but I never took time to read it. And once I became a publisher, it was actually Patrick Rennie. He's like, Steve, you better put in that OGL and take a look at it and put in all the copyright. And I did. I went through it and I changed all that stuff. But it's interesting how this one little piece of paper was able to create such a huge and vibrant community. And now it's only now that people are starting to realize that this little piece of paper that probably 99% of people never even heard of until last week can destroy this community if taken away.
And that's a very good point.
It's kind of amazing.
Yep.
But I will say that we did just come out with ourselves. Battlezoo Ancestry Zero Monster Slimes. So if you want to play a slime, you check it out at battlezoo.com. And again, do like and subscribe.
Pokemon, we've got Eldamon coming up this year too. I mean, assuming that the sky doesn't fall.
Yes.
Which are elemental monsters that you can find and collect and join your party.
It was amazing. No one actually ever did a Pokemon type game system. So we are, and we've been working on it quite a bit for years, actually. So we will see how that goes. Opinion, has WotC officially changed from chaotic neutral to lawful evil? Guess you're not going to answer that question. whatever.
I think the company is full of people that love gaming, love gamers, are gamers. I mean, they're not evil anything. They're good people down there.
Yeah.
Like even the business people, the people that are doing this license aren't doing it because they hate humanity. They're doing it because they see a business opportunity and they want to try and make as much value as they can for Hasbro shareholders and Hasbro employees. And like, they don't think they're doing anything wrong. They think that what they're doing is hard, but they don't think it's evil. Like, they're not evil people down there. They're good people down there.
No one who's like the Doctor Who, like the Who song, no one thinks they're the bad man. No one ever thinks they're the bad guy, ever.
Right. That's right. We're not the Empire.
The world is not chaos and law and good and evil. It's more like, I don't know, triangle strategy. They picked the utility route instead, and Ryan picked the liberty route.
Yes.
And those do not have evil or good on them.
That's right. That's exactly right.
Goofy did ask, Goofy Geek, ooh, I like how he spelled that. Why hasn't WotC Hasbro said anything yet? There's a lot going on. One would think they'd have said something by now. They haven't said anything because we disrupted their plans, and this was not what's supposed to happen. I guarantee yesterday they were supposed to probably do some big dog and pony show to announce their new television show of Dungeons and Dragons on Paramount Network, and they were radio silent, and I pretty much can guarantee that was probably not the plan, and that is because of disruption.
Yeah, look, I think there is an answer, and the answer is that something is happening inside that building. Credible reports were they were prepared to make these announcements on the 4th of January, and it's now the 11th of January. So something is happening inside that building, or they would have done it. Maybe they're just arguing, or maybe they're trying to draft a PR plan. Maybe they have shareholder relations involved. I mean, I don't know, but something is happening inside that building.
So we obviously can't keep going on forever, but this has been, I gotta have you on again if you don't mind. I mean,
super fun.
I will
Anytime.
I will make you a third co-host or a second co-host. This is amazing.
I got enough streaming in my life.
See ya, Mark. See ya, Mark. I know. Yeah, no, definitely have you come back.
See you, Steven. But no, Ryan, your answers have been so amazing. You have like definitive answers and anecdotes, and even when you were like, "This is totally my speculation," like it was a great answer. It matched everything Steven has been saying for a while. So at the very least, two people speculated similar things.
Well, it's just as someone, I've been playing D&D since the 70s. It's just nice to find another Grocknark and talk about these long time. No, it's because, you know, we talk about it. I mean, I've talked about it with my D&D and Pathfinder group. It's the same stories we keep telling each other over and over again. Yeah. So it's nice to hear other stories from other perspectives of people who have been there. And yours are even more
on this stream. I only started in like the 90s. That's like
that's still pretty old. That's still pretty old.
That's super new.
I hate to tell you, but it's been 30 years.
Yeah, I know, right? I'm like, that's not as, it's like, what's only been? I'm like, you're getting up there, Mark.
It's been a long time, but I'm a noob on this stream.
No, but it is fascinating.
We live at a really unique time. I mean, Steven and I, we live in an incredibly unique time. We are young enough to have been in the hobby at its birth and to have watched the people who created it create it in real time. And we are young enough to still be playing it and engaged at a time when the hobby is bigger than it has ever been, ever. Like, one of the greatest moments of my life was being on stage with Gary Gygax at the big announcement in 1999. Like, it was amazing that he was still alive and participating, and I had gotten to the place where I was at, where I got to be on that stage with him. Like, we lived through a very unique period. Now, unfortunately, a lot of those guys have died, so that period is closing. It's like the closing of the Old West, right? Like, you can never go back. But in that window, it was truly amazing that we were the bridge generation between the founders and the current generation.
I know. What I can't even believe is, as you said, a Critical Role. I mean,
right.
I mean, I went to Gen Con, and these people playing D&D on a stage sold out at a huge venue. I'm like, could you imagine ever in your entire life, Ryan, that people would pay money to watch people play Dungeons and Dragons? Ever.
And you know, it's purely a lack of imagination, right? People pay to watch golf.
If they'll
Right.
pay to watch golf, they'll probably pay to watch really creative people be clever. It's like improv comedy. Like, why was it such a surprise? I don't know. We just doubted it. Like, I know that the games that I sit in, which were correctly described by a friend of mine as 20 minutes of fun packed into 4 hours, would not be the kind of thing I would want to watch on television, like for entertainment purposes. But failure of imagination. Apparently, you can make an hour of fun packed into an hour. So maybe we should do more of that.
Yeah, I am actually a huge fan of Harmon Quest, and he had nothing but improv. Like literally, the people from whose line is it anyway? The hosts and the people on his game, and watching that was I never missed an episode. It was amazing seeing professional improv actors play Pathfinder. They actually didn't even play D&D. They played Pathfinder.
Yeah.
Incredible. Absolutely incredible. So I can see
I liked
it.
Harmon Quest, but I was very sad because they had the voice actress who played Korra from Legend of Korra, and they did not have her play a kineticist. And that I feel like that as the author of Pathfinder First Edition Kineticist, that was a missed opportunity.
Right.
No, so
I
close.
know.
Yeah, so close.
By the way, Battles of Eldamon, not only can you play an Eldamon trainer, but you can also use elements like
You can take the element into yourself and
kind of like Avatar. So we're like, let's just take Avatar: The Last Airbender and Pokemon and put them into one product.
Sounds great.
Yeah, I hope so.
License sprint money right there.
There we go. That's what I'm praying.
that's what we hope.
Yeah.
But we'll see how everything happens.
Yeah, and we're making it using OGL. We're trying to make
OGL
it
1.08.
Yeah, 1.08. We're trying to make it so it will work with pretty much any system. So that if you want to use our Eldamon in Starfinder, you can. Like we're using exactly what you said, the templating method, where we're trying to make it so easy to use and so agnostic that you can just put it in any system. So we do have one last question. That'll be the last one. One D&D for the Williams on her dark throne in the land of Hasbro where the lawyers lie. Okay, it's not even a question. It was a
Not
statement.
question. It's like poetry from
Poetry.
Kite the Twin Blade.
Poetry on motion. So, by the way, my personal question. Legend of the Five Rings.
Oh, okay.
Is it coming back? Man, I love that game. I love that. Was it the card game? Man, that thing was great. I love Legend of the Five Rings.
Yeah. Among the other amazing things I've done in my life, I co-created Legend of the Five Rings.
Yeah.
It has a good custodian at Asmodee. I know that team is working very hard on it.
Okay.
The head of Asmodee North America is Stephen Horvath. Steve is a committed, longtime L5R player, and I am sure that he wants that brand to thrive and grow at Asmodee. And so I have all confidence that they will produce great content for people who are fans of Legend of the Five Rings.
Yeah, I love Legends. Back then, do you remember that it was like Legend of the Five Rings and was it Deadwood or Deadlands? Deadlands, that was it.
Deadlands? Yep.
Wow, I love those games.
Did that too.
You did Deadlands?
So we did the card game Doomtown.
I love Doomtown. I didn't know you did. I love that game. I used to play it all
that was
the
a Five Rings
time.
publishing game. We did 5 trading card games in 18 months. We did Legend of the Five Rings. That was the thing that,
I love that.
created the entity. We did Burning Sands, the BattleTech relaunch at Wizards.
Yep.
We did a Rage relaunch.
Yep.
And we did the Deadlands game. We did the Dune game.
I remember. I didn't play the Dune, but Deadlands, beautiful art. I love the whole concept of the cards being playing cards.
Yeah. Don't have to explain this complicated system. It's just poker.
It's well, because I play a lot of poker. So it was a no-brainer for me and my friends to play. We're like poker in the Deadlands with like trading card games. Sign me up, baby, with beautiful art and like undead like monstrosity. Oh God. Wow, that was great. I love that thing. Good job.
97 was a very good year.
97. Back in the heyday when Magic was exploding, and it was so nice back then. And then, well, be careful what you wish for.
Yeah.
We think about it, it's like Wow, wouldn't it be nice if everyone in the world knew what Dungeons and Dragons was and was playing
Right.
it?
Now they do.
Now they do, and
See what happens.
I know, this is
See
what
happens when
happens.
Wall Street cares about Dungeons and
The
Dragons.
Right.
monkey's paw curls up and
I-
your wish is granted. Now Wall Street is involved.
exactly. This literally is a monkey paw wish. It's like you wanted
Yep.
it, you got it. It's, oh God. Well, Ryan, I don't want to keep you because we've been going on for more than 2 hours. Plus,
Yeah, it's
actually,
been awesome.
it has
Super
been
fun.
so much fun, very informative. We have learned once and for all where it came from, and most likely that it cannot be revoked. That's all that really matters. And we're going to probably find out a lot sooner than people think whether or not that will hold up in court, because that could be
Yeah.
a bench ruling. So hopefully this
I
will
think that's
be
true.
a very quick fight. Where can people find you, Ryan, if they're looking for you?
Yeah, so I'm on Twitter at rsdancey, Dancey. And I work for Alderac Entertainment Group. So if you have a business question, you can email me at rdancey@alderac.com.
There you go. What are you excited that they're coming out with, that Alderac's coming out with?
Well, it's so interesting to me. We are really a board game publisher. We don't. AEG has published role playing game products in the past, but it hasn't done so in a very long time. And it stopped long before I became a part of the company. So one of the board games that we published with our partners at Flat Out won the Spiel des Jahres award this year, Cascadia.
Wow.
This game right here.
Mhm.
That is the German Game of the Year award. It's the most important award in all of gaming. So it was pretty cool that they won that award, and we were happy to be their partners in that game.
Wow.
Yeah, I was just telling somebody the other day how interesting it is to me that the board game world does not have the same kinds of copyright issues that the role-playing game world does. The board game world operates in essentially an open content zone at all times. We are much more like the fashion industry than we are the publishing industry. In the fashion industry, designs cannot be copyright. So anybody can see a design coming down a runway and make their own versions of that. They don't have to pay anybody for anything. They just do it. And that's the same in board games. Anybody can use any board game mechanic. There's no licensing required. There is some ethical issues in that you don't want to be perceived as ripping off somebody else's game design, but there's really no legal framework around protectability for board game rules and concepts. So a lot of the lessons that I learned doing open content development for role-playing games are applicable in some way to the board game world, but there's just a lot less licensing. But it is pretty interesting that the two spheres do overlap quite a bit.
Yeah, I mean, that's why you see Monopoly clones all over the place. People come out with
that's tricky wicket. I wouldn't want to get into that target.
I know, I would not, but people do
That's
it.
a deep pool of
But
nonsense.
I know, but you do see them. You see people who
Yes,
have like
that's
their
right.
local version, or like they do a town version of Monopoly and
For sure.
stuff.
Yeah,
And
I mean, there's plenty of history that suggests that Monopoly significantly predates the game that Parker Brothers bought. But yeah, like I said, that's a deep well of.
we can go into that one because that was actually part of.
That's a
I
whole
know,
other
that's a
person's
whole
job
other
to talk
thing.
about Monopoly.
Well, right, because there was actually 2 games. I won't get into it, but if you want to see the history of Monopoly is fascinating because there was
it
2
really is.
games. There was
it's
one
supposed to be a game about why monopolies are bad.
right. There was Monopoly and Prosperity. And Prosperity was the game of you doing well, and then there was Monopoly, like showing how evil everything is, and the evil one took
right.
over, which is insane. But anyhow, where can they find you, Mark?
All right. Well, so yeah, I'm Mark Seifter. I guess if you've only been tuning in to the last couple of streams, you may not have seen me, but I am on here every week. I'm one of the creators of Pathfinder 2nd Edition. And you can find me on my Twitch stream, Arcade Mark, on twitch.tv/arcademark. I'm here for Roll for Combat Live, and I'm on Twitter as at Mark Seifter, or on my Arcade Mark Discord at tiny.cc/arcademark. So I'll put those links in the chat.
Yes, and I'm Steven Glicker. Everyone probably knows now, a publisher of Roll for Combat. You can find me at Roll for Combat on Twitter, and you can go to our YouTube channel here, and you can go to our Discord at at discord.rollforcombat.com. And if you want to buy any of our products, just go to battlesuit.com. And we have a lot of free stuff up there. If you want to play a dungeon, you can play a dungeon, and it's free. It's completely free. And Mark wrote the Dungeon Ancestry and Race in one day. Well, just one. An April Fool's joke that got out of hand, and people love it. If you want to play Sentient
you laid
Dungeon.
it out in the same day. It was
Yes. One day we're like, you know what would be cool? Let's make a playable dungeon. in one day. It's March 31st. You think you can get it done by tomorrow? Sure. And we did. And then it exploded. And then, and you can play Dragon too. We have a huge ancestry of just Dragon. And just be careful. Don't play them at the same time, because Hasbro might come after you. So that's all I'm saying. So once again, thanks again, Ryan. I'm sure you'll be on this